Playing for inclusion in the list, man.
এই বেঞ্চে নয়, এটা দেখে আপনি
Item number 1.
My lordship, I beg to appear for the petitioner, my lord. My lordship, the matter is in regard to the illegality of recovery of gratuity amount on subsequent date, my lord, on 17 January 2022 and 12th April 2022. Page number 116, my lord. My lord, on 17 January 2022, there was a deduction of 6 lakhs rupees, my lord.
17 January
2022.
Yes.
And subsequently on the revised, the gratuity, that was made 12 lakhs rupees. Page number 130, my lord. Please come. $4,47,641. There was another deduction, subsequent deduction.
First deduction is 6,000.
6 lakhs.
6 lakh. And the
Right.
second one is 4 lakh.
4,47,641. পেজিনেশনটা ভুলভাল করেছে এখানে করেন
Yes.
My lord, this deduction is absolutely illegal in respect to state of West Bengal versus TK Ghosh.
So what did you do? Did you write to the authorities?
I have written to the authorities and the
Where is that? After 21/3/22?
The administrative tribunal matter is pending, my lord. But the bench is not there, and he is a very poor person, my lord.
Again, we are asking you. When the recovery was made, did you raise a grievance before any authority? If not, how you will get over Section 20 of the Administrative Tribunals Act? Tell us. Issue of maintainability will arise before the tribunal itself. That you cannot overcome because the tribunal is not functional right now. You have to comply with that requirement. What is Section 20? Read Section 20 of the Administrative Tribunals Act. Sir, give it.
They should have availed the alternative remedies also.
It's not alternative remedy. That's a statutory requirement. Don't argue alternative remedy. That's a statutory requirement. Read 21. The tribunal shall not admit unless it is done. It is couched in negative language.
But my lord, the
Don't
tribunal
try to
has
simplify it as if it is a normal alternative
My lord,
remedy thing. Yes.
sincere apology, my lord. But
Yes.
the tribunal has admitted, my lord.
So therefore, we should overlook this illegality, this statutory requirement.
My lord, then I have to take the instruction, my lord.
What is this? You wait for 2 years after the recovery, you do nothing, and then you come to the tribunal as if 20 and 21 does not exist. And because the tribunal is not functional, that's the provision will not get obliterated. And you give a declaration that it is in compliance with limitation as required under the Act. How it is? Please read 20 and 21 together, what it says.
Unless the other remedies are exhausted.
Just see why we are asking query.
But my lord,
Learned advocate for the writ Get the book. Take the book.
My lord. Item number 2. My lord, item number 2, I beg to appear for the petition in this matter, my lord. My lord, this is application for compassionate appointment, my lord. Petitioner's mother died, my lord. She was died in harness, my lord. She was a great Group D employee, my lord. She was a sweeper, my lord. Died on, my lord. If your lordship kindly takes, my lord, page 36, my lord, the death certificate of the mother, my lord, Kamla Devi.
Not required. What is the issue? Tell us what happened.
But
Why
the
you are
issue
not?
is this, my lord. My mother died, my lord, on
Your
16
father is a government employee. Can you be treated as a destitute? Tell us.
My lord, my father was a government employee, my lord. My lord, my mother died earlier, my lord. My father was drawing pension, my lord, and
Therefore, again, we are asking you, can you be considered a
since, my
destitute
lord,
who is left without the sole bread earner? Can it be?
my lord,
Tell
I
us.
know, my lord, the rule does not prescribe that, my lord, but your lordship may kindly, my
But
lord,
what? We
speak,
should travel
my lord,
beyond the rule.
my lord, in state of Telangana versus my lord,
Forget
N.
about
Suresh
state of
Chandra, my lord.
Telangana. Look at your this DCRB and the scheme for compassionate appointment.
My
What
lord,
does it say?
my lord, the scheme says that I am not
Then
eligible.
you're not eligible.
But
What
Malad,
remains?
but Malad, on Malad, since Malad, when I have applied Malad, I was a Malad unmarried daughter, Malad,
Where
and
is
I was
that issue?
dependent, Malad.
Where is that issue? That issue does not arise. Even if you are a son, can you get it? It's immaterial whether you are daughter and son.
Malad, but
That is immaterial.
your
You are trying to raise something which
consider, Malad, the state of Telangana versus N. Suresh Chandra, Malad.
we will not consider. That is not considering your rule under which you are claiming an appointment. Why should we consider state of Telangana?
Malad, I was
Yes,
dependent, Malad, at that point
learned
of time.
advocate
Your
for
lordship
Item number 3.
Sir, for the petition I have served.
Restoration.
Restoration, let's say there is within time I have filed.
What do you have filed?
Within time I have filed the restoration.
Within time. When it will be outside time.
That's the matter is that the petitioner was appointed for the post of Khalasi under the Irrigation and Waterways Department. Now, subsequently, the petitioner's appointment was given by the executive engineer of concerned department, Irrigation and Waterways.
On casual basis.
Initially on temporary basis, the subsequently the petitioner's appointment has been confirmed as charged employee.
Work charged.
Work charge. That is the
Work charge is confirmation.
so as a work charge, let's say petitioner's appointment. Ultimately, let's say this is
So
there is
first temporary, then work charge.
work charge.
Still not confirmed. Then what happened?
Now, let's say the petitioners, let's say all on a sudden, after discharging his duties of 30 years, let's say all on a sudden, let's say the one person, namely Bhagavan Das, he submitted a complaint against the petitioner. Now, he submitted a complaint that petitioner's date of birth has been, let's say, the tampered by the petitioner while he getting service. Now, let's say the concerned superintending engineer, let's say, formed a committee. Now, committee, let's say the formed committee submitted a report that there is a, let's say, petitioner's date of birth has been tampered. Now, let's say the 24th, these are all facts are prior to the issuance of SOCOS. 24th December 2019, a SOCOS notice has been issued to the petitioner regarding this, let's say, the allegation. Now, in terms of the SOCOS, let's say the 26th December 2019, let's say petitioner replied to the SOCOS. But prior to the reply to the SOCOS, that is 31st December 2019, the executive engineer, who is the appointing authority, directed some other persons, who is not an appointing authority, to pass an order discontinuation of service. Now, let's say subsequently, the impugned temporary discontinuation order has been passed on 9th January 2020. Now, on 16th January 2020, the petitioner also has been terminated. Now,
26 January.
16th January 2020. Now, 17th December 2020.
Where is your reply to the SOCOS?
That's why I have submitted the date of birth certificate issued by the concerned school.
No, when they issued a SOCOS, you did not file a reply.
Yes, I have filed.
Where is that reply?
This reply?
Where is your reply filed to the SOCOS?
Yes, this is a reply filed to the executive engineer on 26 December 2019.
Which page?
That is, Lordship, the page 31 of the opposition.
31.
31 of the opposition.
Position.
So I will come to this, Lordship, later on. Lordship, may I? Because subsequently I got order. This is a long story.
No, because that will make us understand what is your stand. That is your first response. Therefore, we want to see what stand you have taken.
Lordship, subsequently, this, if I tell this, Lordship, the fact, it will be easier. Subsequently, Lordship, I have been terminated, challenging the same. I preferred an application before the original application before the trial. The tribunal, relying upon the fact that there is no disciplinary proceeding, without the disciplinary proceeding, the petitioner's service has been discontinued. The termination, this order, impugn order has been set aside and directed the respondents to reinstate the petitioner in the post. Now, challenging the same order, Lordship, the state has preferred an appeal before the.
This is a state appeal.
No, this is not the appeal. Now, state has preferred this appeal. Now, the state has, Lordship, only on the ground, Lordship, the appeal has been allowed that the Honorable Single, Lordship, the member of the learned tribunal has no authority to pass order. Now, on this sole ground, the order has been set aside. We filed a review application and showed that there is several notification and judgments of this High Court that the learned member of the tribunal can pass an order. Now, Lordship, ultimately review I have withdrawn. Now, Lordship, the tribunal, Lordship, the not sitting. So, Lordship, I have preferred this order.
So therefore, we are still at the stage of your show cause. Where is that show cause? Show us.
So, now, Lordship, kindly come. First of all, Lordship, I'm just kindly come page 25. Who is my appointing authority? That is the Executive Engineer, West Mednipur Division. Page 25.
So basically, your case is that without a proceeding, it cannot be done.
Without any proceeding, Lordship, the only if they have taken a decision, Lordship, discontinuation of a service prior to the issuance of the surplus.
Everything you are arguing as if you are a permanent employee. Now, which provision covers a work charged employee to be afforded the opportunity under WBSR? Just show the provision.
Lordship, just before that, Lordship, Purushottam Dhingra is the judgment.
Before the law, in fact, we should go to the judgment.
Lordship, Purushottam Dhingra, that not only permanent employee, even
Please.
employee who is, Lordship,
Please show which provision you are relying on.
Lordship, kindly come to my this charge employee. Lordship, this I have argued one matter. The charge employee not only governed by the Lordship the West Bengal service rules, but they are entitled to all retirement benefits and Lordship the pay benefits of the government.
No, that is 16/9/2011. That's a different thing. That is a government's decision to give some kind of security of tenure and some benefits akin to permanent employee. That does not make you a government employee within the meaning of WBSR. If you are claiming to be a government employee, which provision you are relying upon, we want to see that.
Lordship, kindly come.
Which rules?
That is the West Bengal Classification Rules 1971.
WBSR.
WBS.
Oh, classification. Yes. So you fall in class 1, class 2, class 3, class 4. Class 4. So where is that cadre which mentions that work charged employees are class 4 employees? Sir, work charge employee, who is a work charge employee? By now it is a well settled law. They are coterminous with the work for which they are appointed. For specific projects and schemes, they cannot claim a parity with, or they cannot claim to be government employees.
Now, Lordship, my contention is, Lordship, that without giving any so cause, without giving any chance of hearing, my service has been discontinued.
So therefore, you are claiming the benefit of WBSR or CCS substantially. Is it available to a person who is not a government employee? That's the moot question.
Judgment of the Purushottam Dhingra.
Let us see.
That is the judgment of the Purushottam Dhingra.
Let us see.
Even a probation period, the judgment related to the probation period.
Those you're not a case of probation.
No, Lordship, this employee service has not been confirmed.
Correct. Therefore,
Now, Lordship,
how this will apply to you?
applicability of Article 311(2).
To a permanent employee on probation, sir. Purushottam Dhingra.
Kindly.
Purushottam Dhingra is a permanent employment after an advertisement in compliance with Article 1416 against the sanction posed, but he is initially on probation subject to confirmation. Here there is someone picked up that you join on such and such post, now you become a work charge. Can he claim a parity with Purushottam Dhingra?
Kindly come the last portion.
Yes.
Such protection also extend to a person who official in permanent or temporary post as well as those who hold the temporary post.
Correct. There's no difficulty in that. You are 100% correct.
I am not a, if your lordship says that I am not a permanent employee.
No, we are not saying anything. We are saying how you claim to be a permanent employee. That we are asking. We are not saying you are not permanent. How you claim to be a permanent employee?
Yes,
that we are
kindly
wondering.
come
Under
to
which
service book.
provision?
Kindly come to my service book. Service book space starts from page 46.
Yes. You have still not shown us your so-called reply. Why you are not showing? We don't.
We have just one quick.
We are asking you repeatedly. What is your stand?
31, page 31 of the opposition.
Who is for the state? They have served you a copy of the opposition.
Yes, lordship.
When?
So we have also the opposition and reply also I have received. 7th April 2026. They have affirmed and we have received it.
Who is appearing for the state?
Lordship, the Mrs. Runu Mukherjee, learned advocate appearing for the.
Yes,
Where
where is the opposition?
Lordship, this is my evidence.
You are sitting here as if you have nothing to do with this case. Your name is appearing in the last order, madam.
I'm not Runu Mukherjee, I'm Kakuli Datta.
Miss Chandre Alam's name is appearing.
Kindly give me 1 minute time, I just.
But they have not filed an affidavit in opposition.
So this is the copy they have served.
Maybe, in this transition between the new panel and old panel, they have not filed it.
Second copy kotha. What is this?
Please be kind to me also.
এগুলোকে বাংলা থেকে ইংলিশে ট্রান্সলেট করতে হবে। হ্যাঁ, ইংলিশে ট্রান্সলেট করতে হবে।
The learned advocate for the writ.
Filed by the
Not filed, served. Not
have been
filed.
served by the learned advocate subsequently.
So you
appointed.
keep your reply. If the same thing is filed, we'll take that day your reply also. If there is some reaffirmation or something required, we don't know what we'll do.
3rd September. এই এটা বাংলায় ইংলিশে ট্রান্সলেট করবে।
Item number 4.
Item number 4, my appearing from accounts in this matter, my lord.
Very nice.
Well, this is an appeal in connection with an order, my lord. The order impugned, my lord, is at page 133 of the paper book, which had been carried into an appeal, my lord, by my clients, my lord, and the order of the Honorable Appeal Court Malad is at 177. Now, this is in connection with a ship. And the private respondent offered the same land down on showroom. Malad is supposed to offer lands, Malad, connection with both dealerships. So in this particular case, they have offered the same piece of land for go down and showroom, my lord.
Part under the MDG.
My lord, yes, my lord, this specific is, by the guidelines of the or companies of the guidelines, my lord. Those guidelines say specifically the same piece of land for showroom and go down. And the honorable once receives the order where they have stated the order of the order of the honorable trial court, page 177, if I may place before my lords the order.
Have you given intimation to the learned?
My lord, the intimation has been served to me, but they have not, probably they have not responded.
So how do we know that you have informed them? We had asked you to do so.
My lord, the email communication, my lord, is with me, my lord, which, my lord, we have, my lord. My lord, learned advocates, my lord, has been intimated, my lord. If my lord desires, my lord, I have served once one.
Panel, he must have represented the panel. Mr. Islam was representing the writ
Yes,
petitioners.
yes, my lord. My lord, he was representing one of the respondents, my lord. And the writ petition was represented by somebody else, my lord. My lord, this third party interest has also subsequent pursuant to my instructions, my lord, has been created in this matter because it's long back, my lord. In the my lord 2021, the appeal was admitted, my lord. There was a stay, my lord, which has been passed by the honorable division bench, my lord. If my lord kindly sees, my lord, 177 of the paper book of the order, so if I may place, my lord, the order. As per the constantly, the appellants are the all company issue is approved by the appellants HPC for construction and use of showrooms. It transpires from the record that both the respondent number 1 and the private respondent number 3, who are brother and sister, are claiming of the same plot of land in respect of which both the proposed go down and the showrooms are to be located. The Honorable Single Bench, by the order impugned in this appeal, September 2021, inter alia directed a fresh inspection to be held to identify whether there is enough space for construction of 2 separate showrooms of specific dimensions. In the event such space is found, then it shall be deemed that 2 showrooms were offered separately by the 2 applicants. Mr. Dr. Learned Senior Counsel appears for the HPCL with Mr. Mukherjee, Learned Counsel, and submits that the order impugned is directly violating the guidelines of the selection of LPG distributorships, clause 8M thereof. Mr. Dr. therefore relies upon a particular restrictive clause in the guidelines which reads as follows. The same piece of land for showroom cannot be offered by more than one applicant for a particular location against the advertisement. In case it is found at any stage that the same piece of land for showroom has been offered by more than one appellant for the same location of the advertisement, then all such applications would be rejected, or if selection has been done, then the same would be cancelled. It is submitted that in view of the clause above, the Honorable Single Bench could not have refrained from the guidelines in the manner as done by the order impugned. In support of his submissions, Mr. Doctor also relies upon a reasoned order of the oil company, the appellants pursuant to the order of the Honorable Single Bench, which sets out verifying the identical schedule of property enjoyed by both the private respondents to this appeal and his sister, the private respondent number 3. Mr. Sharma, Learned Senior Counsel, appearing for the private respondent number 1, and Mr. Islam, Learned Counsel, appearing for the respondent number 3, respectively assisted by Mr. Bari, Learned Counsel, pointed out that there is a 3-story structure over the same said plot of land, and therefore this Honorable Single Judge was correct in holding that upon verification, if it is found that steps required under the guidelines for setting up of the showrooms as available, then the restrictive nature of clause 8N of the guidelines, supra shall not apply. Having heard the parties and considering the materials placed, this court is satisfied that a prima facie case has been made out by the appellants for stay of the operation of the order of the Honorable Single Bench dated 13 September 2021. In view of the ambiguous nature of the guidelines as brought to the notice of this court, it requires to be examined further upon hearing the parties as to whether the Honorable Single Bench, by its order dated 13 September 2021, correctly appreciated the scope and the purported intent of the guidelines. Parties are directed to file their affidavits in opposition to a stay application. The stay shall continue until further order. Since it is uniformly submitted by all the parties, as appeal can be heard ultimately on the basis of additional documents, appellants are directed to prepare an informal paperwork incorporating all documents before this bench. Honorable Single Bench.
Yes.
It is better that suggesting subject to my the server notice, physical notice, because sometimes they might come and say that due to technical glitch, it did not receive the email, or sometimes it did not open the email.
Yes,
So it is
yes,
better to serve a
yes,
notice physically to both Mr. Islam and Mr. Bari. You are fixing a date, indicating the date, serve a notice, then subject to question, we will take it.
Malad, since this is an old appeal, Malad, if it's Malad desires, Malad can keeps it sometime late, Malad, not within 2 weeks or something, because
Because it's late, we want to keep it early.
Malad, I have some difficulty, Malad, in second, the third week of September, if Malad kindly.
So that may be a reason.
Yes.
Because it's sold, therefore it should be.
No, Malad, last occasion, Malad desire, Malad, it fell from Malad that since they are not appearing pursuant to Malad's, the order is appearing, so Malad was pleased to direct me to.
We thought that, you see, these are regular practicing lawyers. We thought you will intimate them. You've just shot off an email and you come here. So you're.
Number 15.
Now see, now we have more insight.
No,
I have more insight.
No, Malad, I am obliged, Malad, I am obliged, Malad.
No,
Malad,
because they have appeared before me. I know that they're regular.
yes, Malad, probably, Malad, I will serve, Malad, and not that probably, Malad, the clients, Malad, might not be interested because there will be there's already I will serve, Malad, I'll bow down.
May be correct. You may be correct. But that can be ascertained only if they appear.
For our satisfaction.
Mr. So-and-so.
Because I had called
Item number 5,
Your Lordship, Mr. Indrajit Dasgupta appears for Cantonment Board, the appellant, my lord. He's on his legs before court 18, my lord, short past over, my lord.
Before
Court 18, my lord.
The trial court records were summoned, Lordship. Possibly they have not come.
a prayer is made for adjournment.
weeks দিয়েছে।
3rd September.
Item number 6.
Lordship, Miss.
Should be from the department.
Lordship, in item number 6, Mr. D.N. Roy is appearing for the appellant. He is engaged in another court, Lordship. I am paying for short pass overall.
Item number 7.
Or I am appearing for the read petitioner respondent.
For the appeal, led by Mr. Mojumdar.
বইটা আটকে গেল যেরকম ভাবে। পুরনো এখানে অর্ডারটা কোথায় গেল? Number on the last occasion, I could not appear because of the heavy congestion in the route. The independence rally and all these things struck me. Even if I came out from my house at 9:15, I reached here at 11:45. It was not within my hand.
No problem.
That's why
But
my
now there is a declaration by the apex court.
now, my lord, the apex court has passed one order. I have seen it.
How we can proceed in
Now,
view
now,
of-
my lord, the problem is this: the order passed by the apex court, in respect, initial order passed by the Honorable Bombay High Court in a division bench presided by my Lord Justice Dipankar Datta. My lord, that is in respect of read petition, not in respect of mandamus appeal. Here, the read petition over in 2012. Appeal filed 2012. 2012 to 2024, it has not been prosecuted for any reason whatsoever. When 2024, at my instance, the matter has come.
mandamus appeal is, what is a mandamus appeal?
Mandamus appeal is the continuation of the read petition.
Then
Then, my lord,
what is the difference,
now,
sir?
now, my lord, one judgment has been delivered. Now, my lord, if your lordship says today,
Is one, the apex court, just see what it says, then
The
you
ap-
make your submission.
apex court says that the read petition is not maintainable. Now,
That's all.
your lordship, can you see?
Please see, let's see the judge.
Please, lordship, can you see? Judgment, yeah. Judgment,
Where is that relevant paragraph?
yes. Yes. Huh? একটুখানি Yes, your lordship, can you see paragraph 32, 33 of the judgment? So, but my understanding is this is the operative portion of the judgment.
Just let us hear Mr. Majumdar first, yes.
And the question of law posed for adjudication are at paragraph 22. These are the questions of law.
We are referring to which
But
judgment?
the judgment of the Honorable Supreme Court, which we handed up on the last occasion separately. 2024 SCC Online SC 965. This one.
মানে এটাই the question for adjudication. এটাই আনসার করেছে।
But we can hand up.
Paragraph 22.
20.
R.S. Medireddy.
My lord.
Yes, yes.
We have that. There is a difference in the paragraphing between the printout from the website and the citation.
May I hand up not the ICC?
No, we have one. So this paragraph 22 of this.
Of the paragraph tally. No, paragraph 22 tallies.
Tell it.
22 tell.
আমারটাও প্রিন্ট আউট ফ্রম দি ওয়েবসাইট যে রিপোর্টেবল মাথায় লেখা রয়েছে না
Yes. Questions of law for
Questions of law posed for adjudication. The questions of law presented for adjudication of this court are whether the respondent number 3, AIL, after having been taken over by a private corporate entity, could have been subjected to writ jurisdiction of the High Court. But this is answered at paragraphs 37, 38 and 39.
হবে না 32 থেকেই অ্যান্সার করেছে No read petitions maintainable. সেটাই তো বলি এক কথা তাহলে আমরা যাবো কোথায় এই জাজমেন্টের উপর বেস করে মনোজ চট্টোপাধ্যায় জাজমেন্ট দিয়েছিল মনোজ চট্টোপাধ্যায় জাজমেন্টটা ডিস্টিংগুইশ করেছে সেটাকে আপহোল্ড করেছে আমার ইন এফেক্ট দ্যাট জাজমেন্ট গন
Here the writ petition was decided in your favor.
Yes.
What was the direction?
The direction was for regularization of service. In one shot.
Yes.
In one shot. Because this is the checkered career history in this matter. Initially, if your lordship permits me,
That's what I'm. This there also there was a pending proceeding. So therefore,
when pending proceeding in respect of writ petitions. Here the writ petition over in 2012 when it was state. Appeal filed 2012 when it was state. Direction for filing paper book was given immediately. Paper book did not file.
Therefore, we are practically considering a writ proceeding today.
Yes.
Now issue of maintainability is being raised. You have to answer the issue.
There
is nothing which has concluded or attained finality between the parties that you can say that now it is over.
No, my lord. It was attained finality.
How it can attain finality when the stay?
In earlier proceedings.
There is a stay, sir, prior to coming into force of this law. Therefore, where is the question of finality?
No, my lord.
If the stay was granted after, then, or if it had been complied, or there was no appeal, and we are considering a contempt, then it may have been different. We don't know. That's not before us.
Probably I am not clear to your lordship. The initially order was passed, Somaresh Majumdar versus Indian Airlines. There, the Indian Airlines, in appeal before the Honorable Supreme Court, after the judgment delivered by this Honorable Court, produced a scheme before the Honorable Supreme Court. And they have indicated that in terms of the scheme, the appointment will be given. If your lordship so permits, I can take in that judgment.
No, we don't want that.
Now-
We are
now-
only
now-
on the issue of maintenance. We are not on merits.
I know, my lord, your lordship is not on merit.
We are not on merits.
Your lordship cannot
You
go.
maybe have a good case, but whether this is the
Now-
forum
now-
or not, that is all we
my
are
lord,
concerned.
here, another question, if it is not maintainable as per the judgment, there is no dispute about it because the apex court judgment is binding on all, Article
All of us,
141.
yes.
So, my lord, I cannot argue on that. I cannot argue that thing. Only thing I can argue, because your lordship kindly see paragraph 22 II. The question was also posted there.
And where is the answer to this?
One of the answer is that they can go to the labor industrial tribunal.
Yes. So the apex court said the division bench has given them a liberty to avail remedy. They are
That's
not. There is
right.
no
That's
question
right.
of being
Now,
non-suited.
now, my
So who is stopping you from availing
No,
an
my
alternative?
hunch is this, because I already got an order from the Honorable Trial Court.
So therefore, you
Now, my
have a better situation now before it.
that's right. Now, my वो ट्रायल कोर्ट ऑर्डर नहीं किया होगा
तो रीट नॉट मेंटेनेबल
हाँ?
रीट नॉट मेंटेनेबल बोलते हैं
रीट नॉट मेंटेनेबल बोलो ट्रायल कोर्ट जजमेंट में तो हाथ फोड़ देना
दैट्स अ continuation of REIT.
How can it be? Now, my lord, if your lordship says today REIT is not maintainable, then my lord, your lordship has to set aside the trial court judgment. That is also one of the problem. If your lordship wants to set aside the trial court judgment, your lordship will adjudicate the matter, which this court, honorable court, has no jurisdiction. So, my lord,
This court can dismiss your writ petition as being not maintained.
REIT petition has already been admitted, judgment has been delivered.
You have said
Now, my lord,
that we know that you have said
now, my lord,
times that the judgment is in your favor.
now, my lord, apart from that, if it is not in my favor, if it is against me, whatever it is, judgment has been delivered. Now, my lord,
As separate and distinct.
now, my lord, if your lordship today, no, my lord, if your lordship kindly,
What is the effect of stay for all this time?
effect of the stay that the ordering portion cannot be acted upon?
Cannot be acted upon.
Cannot be acted upon?
Question of finality.
No, I am not on the finality.
We are on that. Unless it has attained finality, does it lie in the mouth of the writ petitioner to say that now I cannot be relegated to another?
No. I want to relegate. I say probably I am not clear to your lordship. I want to relegate as directed by the Honorable Bombay High Court and which has been affirmed by the Honorable Apex Court. The issue will be that relegated from stage 1 or relegated from the judgment of the High Court. That is the question. Because if your lordship has no jurisdiction to hear out the matter, your lordship will say writ petition is not maintainable. If the writ petition is not maintainable, then the entire judgment, entire issue, entire thing gone. What remains? Only the writ petition. Because writ petition can be transferred, writ petition can be heard on merits.
What is the question of transfer? You file afresh wherever you want to be heard. Why it has to be transferred? There's no question of transferring a writ petition the way it is framed and the other forums. There is a world of a difference between them. So there is no question of remitting or transferring the. At best, you can get a liberty, and Section 14 of the Limitation Act will come to your aid wherever you go.
And in fact, there is no limitation insofar as I mean now the Industrial Relation Code is concerned.
Even if there is,
Yes.
even if there is, we are saying.
It is not a stale claim.
It cannot be, because if he is non-suited by virtue of this judgment, then he cannot be left remediless.
This court may not have a remedy.
Problem for us is, in view of this declaration, can we proceed?
That's right.
That is the whole thing.
That's right.
How can we proceed? We cannot proceed.
But
We cannot.
I have gone through entire thing. You also kindly don't put me into amiss. I am not suggesting to this honorable division bench, but after going
What
through
is
all,
to be done to the judgment?
after going through all the decisions on everything, it has stuck to my mind. The only remedy lies before Mr. Majumdar to approach before the Honorable Supreme Court, taking this situation, what to do. Because the Honorable Supreme Court has the only jurisdiction to hear out this one 136 petition. Otherwise not. Because this court has no jurisdiction. Your lordship cannot say that writ petition is dismissed or writ petition is admitted or writ petition proceeded on merits. Nothing. Because this court has no jurisdiction.
Now take for example,
Now-
let us not for a moment not take into consideration that there is a declaration of law by the apex court. Let us proceed that you have got a judgment from the writ court against some private entity and we are in the division bench. What will we do? Not someone who has been declared a private entity during the proceeding.
Lordship will hear out the matter on merits that the earlier honorable division bench was hearing the matter till this come to their knowledge that the judgment has been delivered with.
What will come in the way of the writ of the division bench to say that the writ petition is not maintainable and therefore without entering into the merits, relegating you to an appropriate remedy, it is disposed of.
Someone, if your lordship relegate me, then in my humble submission, I will go or my standing will be from the judgment of the High Court. Because that judgment cannot be disturbed.
Very good. That is your submission.
Because your lordship can say here the Honorable Bombay High Court also said.
As of today, when we are taking up the matter, there is a judgment which is stayed. No right has been determined.
No right has been determined. Now, as soon as your lordship will say the writ is not maintainable, that interim order passed by the Honorable Appeal Court, that will also go.
Everything will go.
Everything will go.
Itself will go.
Everything will go. Writ petition will also go. Nothing remains.
Yes.
I can only take the help of the judgment determination of the division single judge of the High Court.
How can you? You cannot. You will not be in a position. If it is dismissed as not maintainable, then how you can?
Then, if your lordship says dismissed only on the division bench decision,
Division bench.
on the basis of the Supreme Court decision, they dismiss. The Supreme Court has decided the writ petition is not maintainable. But
In
they are
that case, there was no final order by the writ court.
in that case, there is no final order in the writ court.
So that is a distinguishing feature according to you.
Yes, your lordship can see here that before the Bombay High Court, the writ petitions are being heard in the division bench. Some writ petitions. What are the writ petitions heard in the division bench? Yesterday night, I have found out from the. Now, my lord, we have to take the help of the juniors AI. Because I am too old to take the help of the AI. My son is a Supreme Court advocate. I have informed him. He told me, you take the help of the AI will answer. And then I have taken the Google Gemini's help and Google Gemini answered this thing. Your lordship can
Google?
Google Gemini. That is the AI.
You seem to be more savvy than me, at least.
And the
I don't know
problem
about
once again-
age. I don't know about age.
Because my lord,
Data fed
my
in the
son-
system is once again a human's opinion.
It is a compilation of.
No, my lord,
The
because
data fed is a human being's opinion.
that's right. Because
But the disturbing thing about the AI.
the action of the Indian Airlines or Air India.
Sir, composition of the bench is hardly relevant. We asked you whether the writ was decided. You said no. Whether by single or division, how it is relevant?
No. Because that is also not relevant. Your lordship
If
is
the writ petition was not decided, then there is a distinguishing feature, whether it was considered by a division bench or a single bench, that hardly matters. That hardly matters.
That hardly matters. That your lordship is right, because that writ petition was not decided.
It's not a, we understand, appreciate what you're trying to say. It was not before the division bench by way of an appeal. It was the original court. The division bench was the original court.
And the appeal was heard by, this appeal was heard by the Honorable Supreme Court.
And during pendency of the writ petition itself, the High Court dismissed it for on the ground of non-maintainability.
Yes.
So it was not a case which was carried before the DB in appeal, and in the appellate jurisdiction in intra-court appeal it has been dismissed. This is what you are saying. We have understood. What? How we shall proceed? You tell us. How we can proceed?
I don't find any answer.
Huh?
I don't find it. I have asked many of us, like 40 or 42 years of practitioner, many. In my room number 11, Maharajasi Rai knows it better than everybody of this honorable court, because he was also a part of room number 11. So, in room number 11, there are two parts. One is for younger generation, one for old. I am in the old generations group, and we are sitting there. I have asked practically almost everybody how I can proceed, because we discuss the matters every now and then between us. This is an age-old practice since the inception
That's
of
a very healthy practice. That's a healthy practice.
Yes, yes. We discuss amongst us, and whatever everybody knows, answer this thing.
Oh, but you have to find an answer. You have to argue that you can argue, or you have to say I will go. You can't say that I don't know what to do.
I hope Mr. Majumdar can answer that thing.
He is saying, he is making a one-line submission that not maintainable, which you cannot deny. So the point is, what are you to do? That we are asking you.
That's right. Now, Maharaj, it is his appeal. Now, if your lordship cannot hear out the appeal, then it is the way he has to find out how the appeal is to be heard. It is not my appeal. It is his appeal. He is for the Indian Airlines.
So we can leave it at stay and just delist the matter.
That the earlier division bench also done. And you will also see that before the earlier division bench, we have filed our written notes of argument.
So therefore, see, ultimately, why we said this option, if we delist it saying that we cannot consider it and the stay continues, you are left in the lurch.
I shall left in the lurch.
Therefore, we are asking you, can't just shift it on him that it is his appeal. He will say, I can't argue because now it's not amenable to that.
The answer, I can say that your lordship may jolly well says that the writ petition is not maintainable. Only that thing in view of this decision. No, nothing more.
Even
nothing
other way. Not the Honorable Supreme Court in 1999 gave the not the, the casual persons only a prioritized right of consideration. This has been substituted by the impugned judgment to direct them to be regularized as a one-time measure.
So they can take the benefit of that. Then you do that.
In the meantime, that our requirement has.
We are not saying you do that. You consider doing that. You can say that I will avail, that you can avail the benefit of that observation before an appropriate forum.
Not to enforce that scheme by reason of the changed circumstances. This is probably where we are.
Because otherwise it will become.
That's right. But my employees who are working at that stage, all of them retired, all of them cost 60. Only thing they will get the retirement benefit and other.
Whatever benefit, it is now only a question of some benefits either being made available in terms of the observation or not. So you have to take a stand.
That also by the Industrial Disputes Court.
If it is pursuant to some direction of the apex court, then whatever it is,
yes,
we don't know.
Let him take instruction on the basis of the apex court direction. How they will consider.
We had contested the litigation by submitting that because of the changed circumstances, there is no scope for regularization. The number of aircraft has substantially fallen, has reduced, number one. And number two, all the Honorable Supreme Court gave them as a matter of right, if at all, was to give a preferential consideration at the time of regularization in the event the scheme is implemented. By the impugned judgment, the Honorable Court directs us to implement the scheme as a one-time measure. We don't have this.
Because that they have said that we have this scheme. We will regularize it. This is their stand before the Honorable Supreme Court in earlier Sovereign Homings matter.
That was in 1999.
Whatever it may be.
Much water has flowed down the Ganges in the
but the stand they have taken before the Honorable Supreme Court in order to get rid of the judgment of this Honorable Court.
No, whatever it may be, you can't say. There are circumstances in which a subsequent event becomes relevant. And there are circumstances in which a subsequent development may not. So therefore, that subsequent development, it cannot be just put on the blind spot.
Subsequent development is now here in 2023 or 24,
Correct.
not prior to that. When the writ petition was filed,
Subsequent development is during pendency of the writ proceeding. This is a continuance of the writ proceeding.
that's right. Subsequent development has been taken place. It is from state to private entity.
Yes.
The only distinction arose here. But
That's a world of a distinction.
no doubt for maintainability of writ petition,
Yes.
not for any other purpose. Because if it is state, writ petition is maintainable. If it is not state, writ petition is not maintainable. The other forum is there. So, the forum is there because that the Honorable Justice Dipankar Datta's division bench also said, you have the forum, you go there. Honorable Supreme Court also said, you have the forum, you go there. I can take that forum in view of this decision of the Supreme Court without pressing this appeal or without prosecuting the appeal. Because in view of this decision, probably High Court cannot give any verdict. So, I am placing my case here in view of this decision of the earlier decision of the Somresh Bhomik and others. Because that decision has not been.
How you can press that decision here in this forum?
No, not the decision of Justice Topenchen. The present decision. Not that.
We understand what you are saying. The earlier decision which he has just informed us. Any decision, if it is to be implemented through a court proceeding, then which is the forum? That is the primary issue.
That is the forum of the Industrial Disputes Court.
Then what?
Labor Tribunal.
Therefore, we are asking you. You have to tell us
Now,
what you want.
your Lordship has to devise as to how your Lordship will pass this order. The writ petition is not maintainable.
See, we can look at that issue, subject to what you may argue. Then what do you argue? What is your submission that we have to consider? You tell us.
My submission is this, because the judgment delivered by the Honorable Bombay High Court in the first instance, not after the decision passed by the Honorable Appeal Court, Honorable Single Judge. Your Lordship has already opined the forum, the number of judges is not the concern. Concern is where the writ petition is being heard, whether it is single judge or before the division bench. If it is heard by a single bench, it is also equal to that.
If the judgment of the apex court had said that such proceedings are saved, then there may have been a scope. It does not say so.
It does not say so. It does not negative also that thing, because apex court has not gone into that question. Where the writ petition has already been decided in anybody's favor, where the scope of that. The judgment which has been delivered by our High Court, by my Lord Justice Pranab Chattopadhyay's division bench in Jesup's matter, that was distinguished in Gujarat High Court's decision, in Bombay High Court Tarun Banerjee, and by Delhi High Court another judgment. All these three decisions have been upheld by the Honorable Supreme Court. The corollary is, so far I understand, if that judgment which has been distinguished the judgment of our High Court is upheld, then this judgment has no legs to stand upon. If you Lordship kindly see that the recording has been made by the Honorable Supreme Court here. So I cannot go into this decision of this Ashok Kumar Gupta and Union of India.
We don't know what all you are arguing. We have not gone into the merits till date.
No.
I know the entire background. We don't know.
I am not.
We were only shown this judgment of the apex court on the last day, and we are only on the issue of whether to proceed. If not, what is the way that you can get your remedy?
Only I can get the remedy before the industrial tribunal, because that is the only remedy, because before the Supreme Court there is no scope. If your Lordship dismiss this writ petition, but not on merits, on this, my clients cannot go to the Supreme Court because Supreme Court has already decided writ is not maintainable.
Therefore, we are asking you that take instructions from your client. Therefore, we are asking. We can say that Have to avail the remedies somewhere. Have to avail the remedies somewhere. Therefore, yes.
This is it.
Whether we should dismiss or there is another way it can be done, which may be more beneficial for your client. That is why we are thinking and
No.
we are asking.
My lord, the judgment delivered by the Bombay High Court Division Bench, yes.
One option is that even before the division bench, you can, with liberty, you can go.
Yes.
That option is not over for you.
No.
So if that option you exercise, then no dismissal order is required to be passed. Therefore, we are doing. Because ultimately, you have to assert this right somewhere.
Can I dismiss করা তো?
So first you take this option, whether you want to exercise that option, otherwise we'll see.
Very well. Let me take instruction whether my client says
Nothing stops you from exercising order 23 rule 3 today in this proceeding. Therefore, here. Another option is going to some forum with a dismissal order.
now my lord, order 23 rule.
Because this you cannot say that we have to proceed.
Now my lord, order 23 rule 3 proceedings that I can take if the Honorable Supreme Court did not negate this thing. That's also obstructs me because order 23 rule 3 on that issue, our High Court in a division bench presided over by Sir Asutosh, this is, given the judgment, unless the leave is taken from the earlier bench or the division bench, you cannot say that this has been gone. This is the finding of the division bench of our High Court of 1907.
Sorry,
Your Lordship, kindly say 1 minute. I am giving you your Lordship the relevant paragraphs.
See, what we are saying is, if you are desirous of availing a remedy, relying upon the observation or direction, whatever it is in that judgment which we have just been informed, simply seek to avail that remedy before we approve for implementation.
Yes, that's right.
We can pass that order.
Yes, Your Lordship, kindly pass that order.
For that, we are asking you to take instruction.
Very well, I shall take.
September. 10th September.
10th September.
One.
Item number 8.
And I am for the, and we are for the state. My lord, these are batch of assigned matters before your lordships. My lord, that Juvenile Justice Act matter. The petitioner has been held to be a juvenile, but strangely the learned trial court.
My lord, we had taken up the matter in the other composition. It will come up in that.
My lord,
Somebody is appearing online.
my lord, I am appearing. I am being led by Mr. Rachit Lakhwani, and in item number 11, I
Yes.
am for opposite party number 2.
my lord, praying for a short passover if possible.
No, we are, see, the earlier date, we have considered it in a bench of different composition, so we are adjourning it, it will come before that same composition.
My lord, my lord.
My lord, only my learned friends are since appearing. They had undertaken before your lordship that they will file an opposition. Till date, we have not been served with an
Are you
opposition.
filing oppositions, madam?
My lord, we want to file an opposition. My lord, may be granted 4
Yes.
weeks time.
This is
Those
getting-
If we are adjourning it, let them.
In the meantime, if they can,
It will not be taken.
You want for another 4 weeks?
my lord,
My
already
lord,
this order was passed on by your lordship.
No, no,
23rd July.
do it within 2 weeks, we are giving you 2 weeks. They are for which respondents?
They are
my
in
lord, for item number 11, we are for opposite party number 2.
You have some learned advocate here from your side.
Advocate
My
here.
lord, my lord, I don't have anyone right now there because my lord, I'm in different court today.
You ask somebody to give an appearance on behalf
My
of.
lord, that my clerk will give, my lord. That is not a my lord, the client himself is there present in court. So
Madam, whether you are appearing in the physical court or in a virtual court, you are in a courtroom.
my lord.
Yes, that's all we want to see. Yes.
कितना नंबर रिस्पोंडेंट की?
In item number 11, we are opposite party number 2. Arlene Jared.
নিচে এটা ইনক্লুডিং জটের করতে পড়া মানে অ্যাসাইন একটা বেঞ্চ ছিল না বিফোর জাস্টিস প্রসেনজিৎ বিশ্বাস দু এই সপ্তাহ 10
Much obliged, my lord. And
Item number.
My lord, I'm the petitioner of CAN 2 and 3. I'm praying for some time to file reply against the opposition.
You are for the.
Petitioner
You have filed a can.
CAN.
Who can file by my minute?
For the learned advocate for the.
D79 application has been filed, my lord, against my client, my lord. I have to defend that also.
Item number 14.
Lordship, I am for the alleged contempt, Lordship.
Okay.
Alleged contempt.
Contemner.
Item 14 and 15, Lordship, both matter. SLP.
Order passed by this bench.
Order, initial order passed by Justice Tandon and Justice Biswas. Thereafter, the absence of Justice Tandon.
So today neither of the two judges are there.
Now, the assigned before my lords and the Justice Biswas.
No, before Justice Biswas and this and myself, because he will have to be a member of the. I can be replaced, but he cannot be replaced. So he has to be part of the bench. Because he is a part of the bench
Yes,
which
yes.
passed the initial order.
Justice Biswas was the part of the bench. Presided was Justice Tandon.
Lordship, both matter. SLP was pending till day, Lordship.
Three. I have filed three. Three.
No, I'm saying what is the position? Is it over or something remains?
3 read petition I have filed. I prayed for correction of record of rights on
Yes, consideration is CPN.
regarding
Is there is according to you, it has not been complied?
in one matter they have complied. That was one of the recorded. They prepared the SLP that was dismissed. And now this says in 2 matters SLP is pending. A similar issue. Pendency.
Whatever it is pending there. We cannot pass any order.
Now, kindly consider the common judgment. Issue is same. Partly yes, that was no. That is
What you are submitting, that's why we are asking you.
pendency of this
Because the similar claim is rejected, or we should dismiss the SLP. Whatever you tell us. We have to wait. We have to wait. The state or respondents, they have the conflict.
that they are complying, my lord, sir. Now, today they are
Submission to what avail, that we are asking you. What do you expect us to do?
certainly, the SLP is pending.
Wastage of time.
Only-
Both matters.
আলাদা order হবে 9 September দিয়েছে Item number 16, Millard, I appear for the petitioner. Nowadays, yes. দুটো copy, affidavit of service. The last order, my lord, suggests. By hand service refused. And we have also, my lord, send it to registered post with acknowledgement due, my lord.
Before this.
Yes, assigned. Yes, because. My lord, may I?
All service has been effected.
Refusal is a good service, and we then my lord, send it to the lawyer. My lord had refused, and after that, my lord, we sent it to the client. My lord, the other side, not delivered. I'm told delivered. Track report is there. Annex. Let me check.
Once delivered. Page 5 it says delivered.
Yes, my lord, the original applicant in the the tribunal, my lord, this gentleman joined the service in the BSNL, my lord, as a junior training officer, my lord, way back in 2010. Now, my lord, he was transferred from the post from Calcutta to Karnataka, my lord, on 23rd July 2021. Now he was thereafter, my lord, he was released from the post. He moved after the release order was passed, my lord, he moved the honorable tribunal. The tribunal, my lord, had passed an order directing us, my lord, to consider this case. Now, my lord, we had considered, my lord, by our order, my lord, 29th September 2023. Yes. Yes. Millard, the 21st February is the date of transfer, Millard. And Millard, according to the applicant, it is punitive. And not only that,
Transfer to Karnataka.
Karnataka. Now, Millard,
Post Millard, he was transferred issued by GM, BSN Millard.
Which post?
oh, he was in a junior officer.
Junior technical officer.
JTO, junior technical officer. একটু check করুন।
ATOs are transferred from one state to the other.
The first
I'm sorry, Millard, I'm giving. একটু just a minute, transfer টা বার করো। I'm coming. Millard, the first date of transfer is 21st February 2022.
22,
Not 21. 2022.
to Karnataka
Karnataka.
as JTO.
Yes, but I'm giving you the post actually. Initial
JTO. I'm giving the post. Give me Millard 1 second.
the Millard on service. This was communicated through email and WhatsApp. Past and direct to
Now, Millard, as usual. Now, Millard, tribunal from the original application. Submit a comprehensive representation. Circulars.
No, in this order of disposal, this is OA number, please.
350 of slash 21.
So in this disposal order, does the tribunal take note of the fact that he has already released?
No,
It does not.
No.
yeah, I want everything.
Yes.
As per the direction, filed a representation on 3rd July 2023. Considered his representation.
For the last 1.5 years, he has not gone there. This you know.
Yes.
And this battle is going on.
Going on.
Yes.
Now, just speaking of that,
Millard.
Where is that?
One, Millard. Kindly seize, Millard. Our Millard. Volume 1, Millard, proposal.
So therefore, he has challenged that again.
Yes. He said, Millard, Chief
Millard.
Stage. Director asked me fresh reason order and speaking order. Kind enough to stay shown 121 September to consideration.
Second speaking order is of which date?
Speaking order
23, that was again you are. This is the second speaking order.
Yes.
Then what happened?
Page 146, Millard.
Yes.
Yes.
What?
Then Millard, he filed a contempt application. The contempt petition, this was hard.
Alleging what? Oh, so the speaking order is not in accordance with the direction.
Contempt, Millard. The honorable the tribunal, Millard,
Is not in direction, is in accordance with the direction of 4/124.
right.
Now let's see 4/124.
No, the first order,
No,
4/124.
first order is over.
Yes, first order is over. 4/124.
4/124, we have to see whether it is in compliance of that order or not.
Yes. That is my lord. পাতাগুলো লেখা না থাকলে খুব were asking me, my lord, to show and point out, my lord, order dated 4th January 2024. Page 142. Mark page 142. May I read for my lords? Yes. Because I will show, I will try to demonstrate, my lord, that 4/1/2024, which I am showing, if it is read with, my lord, page 121, the order dated and, my lord, 140, sorry, my lord, yes, 141, 121, I can demonstrate.
Earlier speaking order.
No, the order of the first order of the tribunal, 25.
That's not at 121.
No, 121 is the order, my lord.
Earlier speaking order is at 121.
121. The tribunal's order, first order 25/2022, and the disposal of the tribunal, and there is no correlation, my lord. The last part of the order, that is the only reason that ultimately the tribunal had modified its own order. 25/2/2022, when the first tribunal entertained the original application, and thereafter it had disposed it of. Disposal, my lord,
on 12/6/23.
Tribunal, sir, my lord. No, they are disposed 25/2/4.
12 June.
12th June.
12/6/23.
Yes. This, my lord, has no correlation. And, my lord, your lordship possibly, my lord, at least I could not understand the meaning, my lord, why the subsequent proceeding, my lord, was initiated. The court consciously, the tribunal consciously had modified its own order. And that is why I am requesting your lordship, after, my lord, finishing this reading, my lord, which I have just shown as per the query of court, my lord, kindly, my lord, take Spain also, my lord, go to the other two orders, my lord. I am extremely grateful.
So where is the second speaking order passed on 18/4/20?
Yes, my lord, that is at 146, subject to correction, my lord, 146. 146 is the, yes, 146. Okay. ভলিউম 1 টা দাঁড়াও, আমি এটা এভারমেন্ট করেছি এখানে।
And where is his representation of 3723? Which was considered?
Yes. লিখছো না কেন? কোথায় না তো তার আগে হবে। স্পিকিং অ্যাডজাস্টমেন্ট। তিনশো বারোটা দেখাতো 300
127. 127.
117. Your Lordship is taking a 29 September 2023.
No.
3rd July. 3rd July is 117. A15.
3723.
Yes.
চারশো সাতাশ অর্ডারটা
আর এইটা ভলিউম 1টা দেখিয়ে দেন। ভলিউম 1 এটা তোমার কাছে স্পেসিফিক প্যারাগ্রাফ 6 হাইকোর্টের অর্ডার হচ্ছে 229। তারপরে আমি বইটা প্রয়োগ করি। সুপ্রিম কোর্টে
সুনীতকে পাঠিয়েছে
হ্যাঁ পাঠিয়েছে, আমি দেবো কি হবে? হ্যাঁ এটাই দিন, এটাই পাঠান।
So there are two aspects which emerge. One is whether you will continue him in Calcutta or not. That is one aspect. And you say there is no indefeasible right, even if there is a guideline, it will not be enforceable. It at best, it enables him to make an application. This will not come in the discretion, in way of the discretion of the authorities in exigencies of service or administration. Another aspect is when there is a stay all along by the tribunal, why you are not paid
That is
him?
why, my lord, I requested your lordship, I requested your lordships at the first instance that, my lord, the two orders 25/2/2022 and the subsequent final order, my lord, these are to be read in conjunction with this final order, because the tribunal, in a way, my lord, if I have correctly understood the minds of the tribunal ultimately, my lord, while, my lord, disposing the, my lord, the final 25/2, my lord, 2022, kindly sees the order.
12/6/23 order.
No, 25/2/2022 order, my lord, which is
That was a stay order.
that was the first day after
Yes.
the release. And this, and kindly see, my lord, page 110. That is, my lord, this order must be read with, my lord.
110 is which order? The stay order or the
The
disposal?
first stay order.
25 to 22.
Yes, yes. বার করো, একটা বার করো, তারপরেরটা বার করো। তারপরে কত ছিল? একশো দশ। তারপরে কোনটা দেখাচ্ছিল? ফাইনালি যখন ডিজাইন yes, it violates para such and such. The applicant is, since a prima facie case has been brought, direct respondents to file a reply in this matter justifying the transfer of the applicant will join this place of transfer till the next date. Since it was hard, my lord, by the respondent very next day, there was no opportunity for us to use the actual state of affairs. See, the tribunals, the order, 12th June order, 112. Will at the relevant 5, it's paragraph 7. It is also pointed out by the learned counsel for the applicant that the applicant has not been receiving the salary till date. In the aforesaid submission will link to the applicant is directed to make a comprehensive representation, bring his facts, qua his transfer, as well as raise an issue of non-releasing of his salary till date for the period interregnum to the competent authority within a period of 15 days from the date of receipt of the certified copy of the order. On receipt of such representation, the competent responding authority should duly consider the same in light of the observation received such and such, as well as DOPT such and such, and pass a recent and speaking order expecting disposal preferred. The present order is absolute. What does it mean I put this question?
Yes.
So when it kindly sees the last sentence, it takes us nowhere. What does it mean I put this question? Till the disposal of such pair on that interim stage, the tribunal says stay. Then Miller, the tribunal of at the time of disposal till disposal, simply modification with a conscious mind.
Disposal of if for present order here. Nothing.
You have not paid him anything.
He did not join. He did not join. Millard, your lordship, I remember, Millard, in one matter, in Millard, in a military service, possibly, one lady Millard, she was transferred in violation of the policy also. Your lordship, Millard, made an elaborate judgment that way the scope of interference of the court
Is only after joining.
it is only a first join.
That's what we are saying.
He
But
did
here,
not join.
here the tribunal passed an order. You are aware of that order. Can you ignore it?
No, I cannot. I did not. I said, Millard, I released him. Before that, this fact was never brought.
You were required to challenge the order. You never challenged
Today,
it.
Millard, today be there, whatever may be the consequence.
That is why we are saying today, whatever it is, if you have chosen not to challenge that order, if you have chosen to consider the representation knowing that there is a stay, the stay order clearly says that he or she cannot be compelled. Then what is stopping of salary?
Millard, compulsion means that I, Millard, have taken a punitive steps against an employee.
Therefore, stopping a salary, what else is punitive?
A man has to work. I cannot recall my order. The moment Millard tribunal was in season of the matter, Millard, tribunal's first order 25/2/2022 has no correlation. Millard, kindly sees.
We are what you are submitting regarding interference in this transfer substantially. We understand and appreciate that. But we have to consider your conduct also.
I know, Millard, what pricks the conscience of the court.
We
Millard,
have
I
to
understand.
consider your conduct also.
Millard, the court. But the question here is, Millard, the court may kindly take note of the fact that the interim order does not decide the case finally. The interim order 25/2/2022 was marked, it was an ex parte order.
Can we contemplate of such a situation, any officer ignoring or sitting over a direction?
No, I can.
There is a specific direction saying you can't compel him and you don't pay. What else is a compulsion?
I released him on the office. I cannot be Lord. This the matter went to the conduct.
Therefore, you had the option of filing a miscellaneous application. You could have said it is past ex parte. There is no scope for doing it. You sit over it. That's what you are saying.
But I am saying that your
Having acted like this, can you expect any relief?
There is no contempt before the court of an order dated 25/2/2022.
You have drawn us to
No,
this
no,
order.
no, Milord, kindly cease. Milord,
You have drawn us to this order.
No, your lordship, Milord, the 2025-2 order has been merged into Milord 12/6/2023. If that is the legal
You
interpretation.
asked us to look into this.
Milord,
You have asked us to look into this order.
yes.
Please see the earlier order. When we have seen it, then we are realizing.
Milord, kindly cease. This order has to be read in its entirety, Milord. The tribunal, on the one hand, while passing the interim order at the admission stage, Milord, itself, Milord, disposed of the matter, Milord, demolishing the entire memory, Milord, deleted the entire memory from the earlier order and said, only Milord to consider. That means the tribunal had consciously took note or taken note of the situation. Petitioner.
The meaning of the last sentence.
Yeah, I don't know. Till the disposal, if preferred, the present order is made absolute. Which order?
Which order?
This is the kindly see the earlier sentence. Milord, we must control our language, Milord, in a curial combat, which is the highest court of the state. I only can point out that's whether this order, Milord, takes us anywhere. That is, Milord, the only Milord.
Now let us see the next order.
It is also now, Milord, sees after this order was passed. 29 September 2023.
And in the second order passed in the next OA,
that is Milord.
There is only a direction for passing a fresh reasoned order.
Oh, that is, and thereafter, Milord, I speaking order was passed. Page 156,
So fast, how we can keep up with you?
Sorry. 18/4, I have passed an order.
No, what we are saying is in this proceeding, in the subsequent OA, was there any interim order of stay?
No, that is why I want to place it. 4/1/2024. Page 144, fifth paragraph. In view of submissions of I start reading from page 5, para 5.
Para 5, yes.
In view of submission,
Very well, at the admission stage, we have understood. You need not go so slow.
With the direction upon the competent respondent to consider the contention in this regard to pass a fresh reading, keeping in view the extant rules as well as the law laid down by the Honorable Apex Court within a period. Such and such certified copy of this impugned order is hereby stayed. Then, Milord, still the competent authority.
Now let us see the order passed by the contempt court.
Contempt court, Milord, we came. That is, Milord, I kindly, Milord, takes pain to turn paragraph 6 of my repetition in before your lordship page. That is the volume 1. This is, Milord, paragraph 6.
5, where is P5?
Yes, Milord, I'm coming. The paragraph P5. Just a minute, I am 192, Milord, possibly.
5 is 192.
192 is the second one. Second one. Column 1. Transfer वगैरह देखे चलो ये.
This is the 94 of 2026.
P5. Yes, that is what my lord is asking. Possibly.
194. Starts from 194.
Milord, before your lordship, Milord, subject to correction, if I may take my lord's kind attention.
No, this order has not been enclosed of 28/4/26. Sorry, 13/4/26.
13/4.
Yes.
That is, I said, Milord, in paragraph 6 only, that contempt petition was extensively heard and the same was reserved for order 13/4. However, instead of pronouncing final order, the Honorable Tribunal proceeded to issue an interim order whereby the registry was directed to issue notice to alleged contempt of Debashish Sarkar, Kolkata, to be present in personally on the next date of hearing. The said order was challenged before the Honorable High Court WPCD 94, particularly as in the direction whereby Devashish Sarkar, ex-CGM BSNL, who had superintended his work to appear personally before the Honorable Tribunal. In effect, on the date, contempt rule was issued ex parte against Devashish, who had retired from service much earlier. Challenging such order, Milord, Annexure P5. This was disposed of by this Honorable Court, Milord. And Milord, it says to consider everything, Milord. Whatever I want to say, I accordingly, Milord, filed, my client filed MA 420 of 2026. Milord, this was dismissed. I came before your Lordship.
Where is that order?
That is, Milord, impugn. No, এই order.
MA
High Court
420.
229 is the High Court's order.
No, 420.
MA 420. MA 420, that's to me. Annexure P7, third volume. 4/1/2024. For P7, it starts from 427. 2nd July 2026, Miller, page 427.
Third volume, last annexure.
Last.
P8.
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 नहीं ना MA 420 টা কোথায় গেছে গো MA 420 পেজ 427 না অ্যাপ্লিকেশনটা না MA অ্যাপ্লিকেশনটা
ঠিক আগের পদ্ধতি
What happened on 11th?
11th we prayed for adjournment, no? 11th what happened? On the last 11th August we prayed for adjournment. Yes, 20th is the ajke date. Today is the date before the tribunal.
So what happened?
I do not know. It is yet to be taken up for consideration. চলে তো এই জিনিসগুলো
What has been written is 429.
তোমাদের কাছে আছে বলে
Since he has retired.
judgment.
So apart from this fact that the gentleman has retired, you have raised any other grounds in the MA?
Sorry, minute.
In your application for recall, did you raise any ground other than the fact that the gentleman has retired?
No, Milord, we have two submission, two limbs. First of all,
in your miscellaneous
yes, Milord, that is one aspect, and the other aspect that when the tribunal was quite aware of the fact that the affidavit of compliance had been filed, and Milord, and Milord J.S. Pari had on the last day, Milord, that if the consideration, even if wrong, if the court says no, it is not a correct consideration in law, the contempt.
Therefore, we are asking you in the application, apart from this ground that the gentleman retired,
yes,
have you raised any other ground that there is substantial compliance?
Milord,
and
kindly, Milord, page 290, The 238 is the MA 422.
Tell us which paragraph.
Yes,
Just
yes.
point out.
I'm just a minute. 232. States that in compliance, I'm reading paragraph 4 minutes for my lord's kind consideration, that with the directives of the Honorable Tribunal in the proceeding, whether pending or disposed of, involving the parties herein, the said authorities have till date never resorted to any disciplinary action to force the applicant to join his post in Bangalore. We said, my lord, further that a direction dated 4 the operation of the speaking order, the authorities make the respondent number concerned to make the respondent residence post as incomplete understood. The respondent number 1 in the content this comes in time speaking orders, but it's such and such transfer state with the respond actually this content proceeding, which is impermissible. Issuance of the speaking order that in 2024, pursuant to the direction passed in OA 14 of 2024, the BSN authorities concerned had already put unconditional apology in their affidavit submitted during the proceeding in COF CP 61/24. The order substantially complied. Still, the action of supervision, so Shankar was despite such knowledge, the said price was evidently suppressed on the tribunal. Part of the BSC is concerned. Action passed by the Honorable Tribunal costing a willful and deliberate violation of the order passed by the tribunal. In the unconditional apology,
Paragraph you have said about the speaking order of 18/4/24.
I said, my lord, in paragraph 5, I categorically said that the BSN authorities concerned time and again in their detailed speaking orders dated 29 September 2023 and 18/4/24 clarified their stand quas transfer of the respondent in pursuance of the order.
So this contempt was filed alleging that 18/4/24 is not in compliance.
That is, my lord, that is why, my lord, and we also placed and I need not show, I also, my lord, tried to pursue, my lord, the Honorable Tribunal by showing, my lord, only one judgment, Dr. Jamila, 2024 reported in Live Law Supreme Court 3, State of Uttar Pradesh versus Associate Retired Supreme Court High Court Judges, Calcutta, Allahabad. Now, my lord, it says that, my lord, page, before concluding, we must note that the conduct of the High Court in frequently summoning officials of the government of Uttar Pradesh, the appearance of government official must not be reduced to a routine measure in cases where the government is a party and can only be resorted to in limited circumstances. The use of power to summon the presence of the government official must not be used as a tool to pressurize the government.
We don't see any order summoning anyone.
No, no.
Only says,
Devashish Sarkar, now the court tribunal said we will call the present CGM.
no, it just says give the name. It does not say ask anyone to appear.
But my lord, MA 4420, my lord, first of all, the court's consideration that your lordship, if I have correctly understood the minds, although many a times I did not, my lord, any question comes from the court, I took it negatively, my lord, that it is an effort. But here, my lord, the tribunal,
No, what we are saying is they have not directed for appearance. They have only said now since that man has retired,
No,
you give the name of the other person.
I said, my lord, the tribunal in substance, my lord, proceeding with the contempt is
Very well.
Hey, that's it. Lord, he is, my lord, doing well now.
There are so many dimensions, you know.
Yes, Lord, kindly don't lend.
He will not get anything for all this time.
But that is not the Millard here, neither here nor there, Millard. Kindly, Millard, have the charity to consider this aspect. If he has any entitlement, he can issue a fresh, can initiate a fresh proceeding. But in a scope of content, Millard, the tribunal's proceeding is a very limited scope.
That is why we are saying there are so many dimensions.
Yes,
You
sir.
can't just confine to one.
I cannot, Millard.
Yes, take down. And services.
17th September interim order.
Maintain a seamless internet connectivity for the High Court.
Item number 17.
I appear for the petitioner. Appellant petition. I am challenging the judgment passed by the my lord learned single judge of this HON'BLE court. What happened, my lord, in this case, my lord? Initially, my lord, the government of India, my lord, passed an order for inspection of the records of the company. Well, in exercise of power, my lord, under section 206 of the Companies Act. Now, my lord, subsequently, my lord, the report was submitted. In the report, it was found, my lord, that nothing adversarial could be detected against the companies. My lord, 162 companies were there. Thereafter, my lord, the government of India passed an order, my lord, under section 210 of the Companies Act for directing for investigation in respect of 162 companies run by one Sharda group of companies. Now, my lord, after, my lord, the investigation order was passed by the government of India, now, my lord, the concerned investigating officer, well, issued a show cause notice, my lord, under section 217 of the Companies Act, saying that you are requested to produce all these documents. Now, my lord, a writ petition was filed challenging the show cause notice, and ultimately, my lord, the order passed by the government of India under section 210 of the Companies Act has been set aside. This is the crux of set aside. This is the crux of the matter, my lord. My first point would be before your lordship that mere issuance of show cause notice, my lord, would not give any cause of action to the petitioners, my lord, to approach before this HON'BLE court. Secondly, my lord, learned trial judge proceeded on the basis that no reason has been assigned for passing an order of investigation under section 10. But I have submitted before the learned single judge. Look here, I cannot elaborate the reasons. If I disclose all the reasons, then what remains to be investigated? But learned trial judge, my lord, proceeded on the basis that
Has notice been served?
yes, my learned friend is appearing. But if your lordship, my lord, kindly takes, I just point out, my lord, the order passed by the government of India, my lord, under section, my lord, 210. But if your lordship, my lord, kindly takes page 336, my lord, it is in volume 3.
By 2022.
Yes, my lord, 11th May 2022. May I just place it, my lord? Whereas the central government is empowered under section 210 1B 1C. As you also got it.
Any opposition or something is to be filed? No.
So, my lord, in the writ petition, my lord,
Final hearing.
In the read petition, my lord, we also file an application for vacating the interim order, but there is no such opposition and reply. Well, this is a pure question of law. My lord, your lordship, my lord, can hear it now.
Yes. Where is what you are trying to show?
Yes, I am trying to show, my lord, page 336. The order of the central government is in volume 3.
RDAR means Regional Director
Regional Director
of
Eastern Region.
Eastern Region. So this is not the order which has been interfered with.
This has been set aside.
This one has been set aside. Where is the order setting aside this order?
My lord, this is your lordship would get it, my lord, in the memorandum of appeal. My lord, judgment dated, my lord, 18th of March 2026, which is under challenge before your lordship.
You have filed the certified copy.
I just check it, my lord.
See, because the stamp report says that after certified copy, they will report about the delay.
It was filed with the leave of the Honorable Court.
That is all right, but we need not inform you all the procedure.
Certified copy has to be filed.
Once certified copy is given, they will give us report. You may say that for whatever reason, then only we can consider.
I'll check it, my lord.
Check it out.
Apply for the certificate copy, then it come.
Yes.
Timed appeal.
Therefore, we are not saying all those things. We need not say those things.
I'll just check it, my lord.
So let us overcome this, then
Yes,
we will
yes,
consider.
And next week, my lord.
Have you filed it or not filed it? The learned advocates representing the maybe we should ask, we should list it on the Monday week. That will give you the entire week to take care of it.
Yes.
List on Monday week,
Monday week.
not Thursday.
Deep.
Putting aside matter item number 1.
Yes, sir.
Lord, I am for the contemner. Lord, I have instructions that the amount has been paid.
Paid.
So, Lordship, there is the instructions.
Why don't you serve a copy on the learned advocate for the writ peti- the
Lordship, I will.
applicant,
I will.
the learned advocate for the fine. There is one appellate side also. Appellate side.
Appellate side item number 1 under the heading for orders.
See, we have heard this matter at length. After May, there is a change of the state councils. So who is to appear for the state? We had kept it under orders for just one thing, to see whether there was any regulation issued under the 95 Act in the state of West Bengal. We have found it. But since now the new state council will represent. Yes, we remember everything, the delay and all that. We have taken detailed notes. That will decide. We remember the thing without any ambiguity, but since after May the panel has changed, we did not pass any order.
I shall give a notice to the learned
GP, yes, you serve a copy.
along with copy of this application.
Ask them to come.
Then will can fix any date, in the meantime I shall.
Next week बोलना.
In view of the new state
On
My appeal arising out of order passed by.
My lord, I'm for the respondent led by Mr. Parth Ghosh, my lord. I'm only praying for not today, my lord.
Mr. Ghosh's date was fixed because he has some problem. Like keeps it any date when they will be there. I am
My lord,
fully ready
next
with
Thursday,
not today will not suffice.
my lord, next Thursday, my lord.
Thursday হয় না এটা next Thursday হবে তো এখানে? Yes, next
27th, my lord.
when he will be there I'll finish.
On a prayer made by the learned advocate for the respondent, we adjourn the matter.
Very well. His Miller has some social work now.
Item number 2.
My lord, I'm for the applicant in this matter, my lord. I'm for the applicant, my lord.
Thursday.
Coal India, my lord.
Same date, Thursday.
Item number 3 and 4.
well, 3, I have for the
Worship, I am for ACL.
pursuant to Lordship's last occasion direction, I have served a notice to the private respondents. And Mr. Sumitabo Chakraborty is appearing. This is issue, my lord.
I beg to appear on behalf of the respondent. You are for the which respondent?
The respondent.
I am for the private respondent, my lord. The parties are now respondent number 9.
Because my lord, the deceased employee has to, my lord, have 2 wives.
Acha.
Well, there is that matter in which there was 2 wives, and the learned single judge has directed that the ACL may consider their application and then decide which wife is to get and thereafter dispose of this matter.
Because of, my lord, the second wife is the private respondent here. He is giving relinquish, my lord, to the first wife as a monetary compensation.
There is a relinquishment by you.
He has given mail the respondent number 9.
So now he is not interested in the job.
No, job he is not interested and also not interested in monetary compensation. Because of she is getting a pension, which is there between the bilateral agreement.
There is no dispute now.
My lord.
Then you approach them for the benefit.
That's why, my lord, I have approached.
So what happened after that?
No, they have preferred an appeal, my lord. Kindly see the landed single judge order, my lord.
The single judge directed you to decide the issue.
Yes,
Directed them to decide the issue who would be the proper claimant.
Yes.
Yes.
Now you say after that decision there is a resolution between the parties.
No, prior to that.
Already prior to that.
That was recorded by the landed single judge.
Then
It's recorded in the impugned order.
Then why?
Sorry to interrupt, Malad, it's recorded in the.
And that is part of the record. We have the second wife has already given the undertaking and by way of affidavit.
Where is the direction?
Page 84.
84.
Of the stay.
Impugned order.
Please, sir. Yes.
Page 84 of the stay. GA.
Of the stay.
Of the stay application. GA.
GA number
236. My lord, actually, in this matter, the facts were very convoluted and we were not allowed to prefer an affidavit to file a report or an affidavit. Therefore, the learned single judge decided either to let us decide this matter and then come to a conclusion. Because initially the brother of the deceased claimed employment, then he preferred a writ petition, thereafter he withdrew it, thereafter the first wife claimed employment. A lot of things have, they claimed MNCC, then they came up with a settlement between themselves. So there were a lot of disputed facts, half of the documents are also not attached. Therefore, there was necessary to file an affidavit, but however, it was not allowed and rather it was directed that we only decide and then disburse.
So the claim is confined to monetary compensation.
Yes, now it is confined to monetary compensation. But initially in their settlement agreement, which they have referred to, they said one party will get monetary compensation, take the monetary benefits, the other wife will get employment. So all these kind of agreements.
Both benefits are not available.
Both cannot be claimed at the same time.
You have
As
to
per
claim either
NPW.
of the two.
Either of the two.
Either monetary compensation employment.
So after 30 July 2012,
Nothing.
what comes in the way? Once there is a relinquishment on 30th July 2012,
3rd July.
3rd July, yes, 3rd July. Then what is coming in the way?
Seventh, page 80.
Because the single judge has said that the respondent number 9 will give an undertaking on affidavit.
Yes, and then I decide.
So decide it. Why? What do you want to say now?
Lordship, at that point we had preferred the appeal since it was said that from the date of death. So that part we had approached in appeal. Now it has been decided. So
Yes,
that part
we will dispose it off. How much time you will take to 8 weeks? It was directed, so 8 weeks from date. Yes, please take down.
Lordship,
page 73 agreement between me and the no objection given. Page 75 column number 8, that both the parties have made a affidavit is respect of no objection for getting employment and monetary benefit in each other case
This
existing
cannot
separate-
be, sir. This is not tenable under the NCW. For both benefits, this agreement is not sustainable. It is opposed to the NCW.
Well, that's why the
Therefore, till this date, there was no settlement of relinquishment, divorce the claim for a compassionate appointment.
but the respondent might never claim before this on
This document does not support.
kindly see the ECL documents kindly. The
We will
petitioner's name has
see,
been
you
recorded.
have relied on P10.
My lord.
P10 was not accepted by the writ court. We were wondering why. Now we see why it was not accepted. Because this agreement is contrary to the NCWA. It cannot be accepted. That one of us will get an employment, the other will get MMCC. How can you? You cannot. So the agreement has to be read as a whole. It is not that it is severable that, okay, you leave that aside and give me the MMCC. Unless she gives an affidavit on undertaking that I don't want the compassionate appointment, you give her the MMCC, I am not making any claim, how you can get? You cannot get. But not sufficient.
But kindly see, since 2012, they have not given offer either the respondent number 9 or the petition.
How can they? On the basis of such agreement, they cannot. You want us to go into this, we can go into it.
No. Sir.
The other option is, we have said in accordance with Maya Bori, you
Yes.
take the MMCC, then you raise this issue if you want.
Then only
Because we, based your submission, all right, you make your submission, we'll decide right now.
only one issue, my lord, in respect of the interest.
Till 2012, there is no relinquishment. Now show us any relinquishment after that. Then the onus will shift on them why they have not given the benefit.
In respect of the interest kept open if the petitioner
We are not saying anything. We are disposing of in terms of my both the
this point has been kept open. It will be.
We will not, sir. We are allowing you to make your submission today. You cannot sustain the claim. Please try to understand what we are saying. Till date, there is no affidavit of undertaking by respondent number 9 that I will neither claim a compassionate appointment nor I will claim MMCC.
Then I am withdrawing the cross appeal.
All right, you can withdraw.
And liberty to file if that liberty, only the liberty.
See, we don't want to give false hope to someone who is in such dire straits.
Then
Either she should come to the court for something or she should better not come. That will only give a false hope and she will be prompted to come to the court again for something which we have found today not admissible. You cannot improve the situation after today. If she is entitled to interest today, she will get it. If not, she cannot get it. So we'll leave it at disposed of. Or if you want to withdraw, you can withdraw. Whatever you want.
Only liberty. I'm liberty to file a phrase if so.
Sorry. I am very averse to passing such orders which generates unnecessary litigation.
Then we'll disposed of.
Disposed of. The cross objection is also as disposed of.
Is rightly because of
She cannot improve the situation today. There is no way it can.
Still, it has not been decided.
Yes.
Yes.
Lord, DCL is not a party to any of this agreement, so that is
You need not say.
grateful, Your Lordship.
Yes.
Item
number 5. Item number 5.
My lord, I am for the applicant in this matter, my lord.
Yes. Yes.
My lord, I'm for the applicant in this matter, my lord. Kindly fix this matter, my lord, on 27th.
27th.
We had also preferred an appeal from the same order. We had preferred it before that. Ours is a 2025 appeal. This is
Not listed.
not listed.
You wanted to come with
Your
this.
Lordship. Same matters could be. We have
So same date, Thursday.
My lord,
As paid by learned advocate for the appellant, matters.
Also, my lord, he will be seeking time, my lord, which, my lord, I say, my lord, Mr. Ghosh is there, my lord. He's doing a matter in 446 where I am the other side. I've kept my junior over there, my lord. On the last occasion also, they took time, my lord. What I pray with your lordship only today to take up only my application for condonation of delay.
Yes. How much delay?
74 days, my lord.
Copy served.
Yes, yes, my lord. I served all copies.
What is the issue?
My lord, here, my lord, issue, my lord, on the last occasion also, my lord, if your lordship recollects, my lord, here the issue is a person died, my lord, employment was claimed by his son, employment was provided, he didn't join 10 years thereafter. His the employee's daughter, my lord,
So
demanded
10 years delay on that side and 74 day, 74 days
that
delay on this side.
my lord.
We'll allow the application. It is, what is the number? GA number 1.
G number 1, my lord.
An application is filed for condonation of delay within brackets.
Because the appellate side at 2 p.m. the second matter is mine. I have to wait.
Item number 7.
My lord, I am appearing on behalf of the respondent writ petitioner. So for the appellate side matter is concerned. There are two matters, my lord, on the identical issue. My lord, one is
For the original side matter.
All parties are here.
yes.
Yes, my lord, and the on the last day, my lord, we had filed a compilation of documents, and my lord, we are otherwise ready to, my lord, proceed with the matter. So, if your lordship allows us, we'll proceed with the matter, my lord, as your lordship. May I
This is
just-
appellate side.
Yes.
Oh, the one is arising from the original side and one is arising from the.
Of the appellate side. No, the issues is common.
Both these matters, my lord, were taken up by the Honorable the Justice, Chief Justice, my lord, and then after that, my lord, they have been heard together. So, my lord, common directions have been passed, my lord, in this matter.
By the division bench.
Yes, my lord.
Yes.
And thereafter, my lord, we have also filed most recently a compilation of documents for your lordship's convenience, my lord. Now, my lord, before, my lord, I proceed, may I give your lordship, my lord, a very brief background regarding what is the dispute regarding which, my lord, we are before your lordships. My lord, on 3rd of August 2017, my lord, the government, my lord, issued an office memorandum under which, my lord, the central public sector enterprises, of which, my lord, Bridge and Roof, who is the appellant before your lordship, my lord, falls under that category, my lord. There were, my lord, certain directives passed on these CPSEs, central public sector enterprises. All these, my lord, related to the retirement benefits or revised pay scales. It directly affected, my lord, the payment of gratuity upon superannuation. Prior to this office memorandum being issued, my lord, it was 10 lakh rupees. That was the capping. And that was, my lord, based on a survey which had taken place and given effect to in 2007. After a span of 10 years, my lord, the government revised this pay scale and came up with a recommendation which, my lord, came into effect from 1st of January 2017. Under that, my lord, revised pay scale. So, my lord, the office memorandum is 3rd of August 2017 and it is, my lord, with effect from 1st of January 2017. My lord, under this office memorandum, the non-board level and non-board level executives and even non-executives are, my lord, given some additional benefits.
So everybody,
mostly everybody. And my lord,
who remains board, non-board, and
yes, everybody. So, my lord, the impact of that was that from 10 lakh it got enhanced, my lord, to rupees 20 lakh. I am talking about the gratuity
for the person concerned here.
Yes. Now, this office memorandum, my lord, applies to all the persons concerned before your lordship. Because all of them, my lord, have superannuated after 1st of January 2017. Now, my lord, the office memorandum gives only one caveat. That is, the affordability of that particular CPSE, whether it is, my lord, in that financial capacity or not. It also spells out, my lord, how to come to the assessment of affordability. Now, my lord, if we take into consideration, as per the office memorandum, the last 3 years profit before tax balance sheet. The date of implementation is 2017. So, the last 3 years profit before tax, as will appear, my lord, the average has to be taken into consideration while giving effect to this office memorandum, because the financial impact this enhancement is going to bring to the particular CPSE should not exceed 20% of the average profit before tax for the preceding 3 years.
There is a formula already fixed.
Yes.
For deciding the affordability.
Well, I couldn't get you, lordship.
For deciding or assessing the affordability, there is a formula already fixed.
Yes, the formula is already there. The formula is already there, and it is not a very cumbersome formula, because just
no, we have understood. You say 20% of the profit before taxes in the preceding 3 years.
Yes, my lord.
If this payable amount constitutes something within 20%, then it is considered affordable. Otherwise, not affordable.
And incidentally, my lord, what appears, the petitioners before your lordship, my lord, naturally could lay their hands on the office memorandum through the government portals, either website or otherwise. Even, my lord, the annual reports of Bridge and Roof, being a public sector enterprise, my lord, is there available before the government portal. So naturally, it is open for the petitioners to see it themselves what is the profit before tax of Bridge and Roof in the year 2014-15, 15-16, 16-17. Simply add them and see whether they fall in this category or not.
16-17 will be taken into consideration.
That is, my lord, a question I was also speaking to my junior, whether 16-17 or not, because
financial year does not end when the scheme has to be effected.
Yes, 16-17, my lord, takes us to 31st of March 2017.
So there's no way of assessing.
And my lord, your lordship is further correct in saying this, because 2016-17 annual report or annual statement is published not before September.
In any case, it will come after 31st March.
it will be, my lord, taken into consideration for calculation, but published naturally in September, not before
Obviously,
that.
it will come after 31st March. Any date after, and here the benefit is to accrue on 1st January.
So even if, my lord, I take that as a stride and I include 16-17, just because it is that year, because from 2017, 1st of January, let me include it. Now, when I come
One
to
way
this,
it can be included because the revision has been directed in August. Much after the financial status was.
Cut short the matter, my lord. The issue has
it
been
cannot be cut
decided.
short.
Another division bench, my lord.
No, my
And-
lord, I beg to
yes.
differ on this. I'll take your lordship's, my
Yes.
lord, to all the materials which is necessary, because we have filed a compilation which goes in with 2 volumes. I'll have to take your lordship, my lord, through all that. But as it appears, my
No,
lord,
no. If there is a similar claim
Yes,
by
similar.
employees
claim,
of
they
the
have also
same
acted upon.
organization, by employees of the same organization,
Yes.
then where is the question of re-looking into it in
Now,
Yes, yes.
now, my lord,
coordinate bench?
Which my learned friend has to, my lord, cross.
but are they
take it to
challenging maintainability?
My lord, whether all of these facts, my lord, there have been 6 rounds of litigation since 2019. In one of them, they have conceded in
So
court.
at least litigation is affordable.
Under
My lord. Yes, absolutely, lordship.
and
I
unfortunately or fortunately, I had the occasion to appear on in this matter. That matter, my lord.
Once on
No,
record.
let us see that coordinate bench order
Yes,
first.
yes,
My lord,
First we'll
before
see.
your lordship visits
And
that
they have
coordinate bench order, my lord,
No, if it is the
My lord, they have
same
also-
issue, then
my lord, may I
Just
just read the judgment.
may I be entitled to make one sentence?
Yes.
I would have, my lord, told your lordship that it is not 20%, it is 143%. So squarely, my lord, it doesn't come within that particular office memorandum. That's the first point. The second point, my lord,
No, no, whether these
These
points were
petitioners-
considered or
Yes,
not. Let us
yes,
see the
yes,
judgment.
affidavit, they have filed the affidavit, my lord. They are, my lord, under single judge.
Just show us where is the
Yes,
judgment, sir. Let us
yes,
see
my lord,
the.
I will show your lordship, my lord. Kindly have a look at, my lord, page 47 of volume 1 in FMA 1405 of 2025.
664.
Yes, my lord. Before I take your lordship, my lord, through this order passed by the honorable division bench, my lord, what is necessary for your lordship, my lord,
This
to
is the
consider
same
it?
organization.
Same organ.
Yes, yes. My lord, here the writ
And
petitioner,
identically situated, my lord.
my lord, here the writ petitioner was one Mr. Mukul Kumar Sengupta,
Oh,
who
name is different.
name is different. That is not the point.
Yes.
My lord, the point is that Mukul Kumar Sengupta, my lord, he got a favorable order, my lord, and he preferred an appeal
Yes.
because he was aggrieved by the fact that interest was not paid to him. So, my lord, the honorable division bench, while considering this particular appeal, FMA 664 of 2024, had the issue before the court, which was only subjected to the point of issue and nothing more, point of interest and nothing more.
So you did not even consider it appropriate to challenge the writ court order before the division bench
Filed it.
for grant of this benefit.
Cross appeal filed.
My
That
lord, no, cross appeal was not filed. My lord, a review was filed, and
That
that
is
review,
rejected.
my lord, in that review, my lord, the honorable division bench has modified the order in our favor and has, my lord, changed the date of implementation of interest. Because the learned single judge, my lord, in Mukul's case, did not award interest. So, my lord, what was the petitioner aggrieved? It was, my lord, not an appeal by the bridge and roof.
No, no, we are trying to appreciate how it helps you by saying all this.
My lord, it
The
helps
single
me.
judge directed for payment of the same claim which they are raising.
A single bench, my lord, has already had directed.
You did not challenge in appeal.
But I did not challenge in appeal.
They went in appeal that why only this much give us more.
Yes.
That more was
No,
granted for.
was more, my lord.
Yes, interest is more.
Only the interest component.
Interest is more, sir. It is
Yes,
not
my lord, I
less.
bowed down. Yes.
So they went for more. That more was subsequently modified to a little less, but still more.
yes.
So how does that help you, sir?
But before, my lord, the ratio before the honorable
What ratio?
division bench, my lord,
Issue is settled.
my lord, the issue before the honorable, with deepest respect, my
Sorry.
lord, the issue before the honorable
We are
division
not
bench,
going to indulge in unnecessary hearing of a matter.
my lord, in that case, I'll have to
Just
take
give
your-
us the points of distinction from the last case. 1 or 2 points. Show us how you distinguish your case.
My lord, the first point
Yes.
is that in Mukul Kumar Sengupta's case, my lord, the documents which are before your lordship now, that is the balance sheets, were not there. Neither was, my lord, the detailed calculation by which, my lord, 143% is demonstrated before your lordship now. So
Those are
these
not
are facts
distinguishing
which were
facts.
not before.
The organization is one and the same. The benefit claim is one and the same.
Yep.
So therefore, in every subsequent litigation, you cannot be raised to permitted to raise a new ground for,
Not even
you're not even,
lordship after 6 rounds.
huh?
Well, not even immediately subsequent litigation. After 6.
So therefore, we at the outset, we observed that at least litigation is affordable.
Single bench, division bench.
Miller will kindly have look at the division bench's order once. Kindly, Miller, before Miller proceeding in that direction, because I would have Miller taken your lordship Miller through the division bench's order on the anvil. That
The
it was
division bench
absolutely
order
of
does
the
not
point of
help you at all.
No, Miller, it doesn't help me.
So then why
The
should
fact
we
which has
go
happened in
through
this
something?
array, it is a fact.
not
Miller,
help
it doesn't change the fact.
It
that
doesn't change the fact that the
office
same
supervisor
claim
is
was
not-
allowed and the same claim was paid by you with interest.
No, Miller, the claim has been paid by me
with interest.
when we haven't paid interest. The claim,
Despite the order in the
Yes,
review, you have
paid
not paid
interest.
interest.
Yes, Mukul Senduti is my client, my lord.
How can you not pay?
Under-
Either you have paid or
Yes.
you have suffered an order in contempt.
Miller, the main claim was paid by us while the writ petition was pending, and in our affidavit in opposition in that writ petition, that order is not before your lordship.
We are wondering how these submissions help you. We have paid in a later date. We have paid after review.
No,
Fact
but it
remains
was
the
Miller-
same claim paid to employee of the same organization
Yes, but Miller,
and registered in the case of another by an organization which is a state within the meaning of Article 12.
yes,
Yes, so you can pick and choose who you want to pay and who you don't want to pay.
but we, Miller, the
Kind of
the
submission you have
financial impact, Miller, was extremely high.
It is for the same period or it is for different period?
No,
Same
it is
period,
Miller for the same
Miller.
period.
What is this?
That is for the same period.
So
I
therefore,
understand what
it
is coming
amounts
from
to
your
the
lordship,
case.
but the
Which are the cases which they have filed? Give us a detail.
Miller, if your lordship,
But the organizations are contesting
if your
at
lordship,
the
Miller, take the
Review,
take the index, Miller,
review, my
index to volume 1, Miller. I'll indicate.
52.
how many cases? Give us a list.
Miller, kindly have a look at the index, Miller.
Kind
It
of
is-
organization indulging in litigation for the sake of litigation at the expense of cost of public.
There are one case pending before the learned single judge, and already my lord decided one case by division bench.
Please, sir, give us a list of the cases wherein this issue has been decided.
Miller will take
We will take cognizance of this.
Miller will kindly
This
take
litigation.
Miller
at
will take
the-
the index, Miller. I have indicated there.
No, let them give us a list. Give us a list.
The first mallard is WPA 15.
But your lordship, Miller, will kindly give me at least 2 minutes of hearing, Miller.
You have already taken quite a
I
lot
wanted to take your lordship, Miller, through the order.
in a matter where there is nothing you have argued for more than
Miller,
10,
with
15
deepest
minutes.
respect, Miller, it may not be res judicata. Kindly gives me an opportunity.
Who said res judicata? Did anyone say res judicata?
Because, Miller, this issue was
Did anyone raise an issue of res judicata?
no, but
Why you are arguing something which has not even been observed by anyone?
Miller, that is what I felt, Miller. That
From where you have got it, we don't know.
once, Miller,
Only you know
holds that
whether a res judicata can be argued in a matter between parties who are
it is
different.
different, Miller. That is what I
There
was
is a
saying.
question of res judicata.
But, Miller,
There is an issue, a state as a litigant resisting a claim which has been paid under identical circumstances. That is the only issue we are saying. You are not a private litigant. That every case you can contest. You are contesting at the cost of the public money. So litigation has to be weighed by you whether it is a valid litigation or not.
Miller, in that
Therefore,
case,
we are asking of the details of all the cases.
Miller, what has fallen from your lordship, Miller,
We may consider some consequences also, sir. We are being very clear.
may I make one humble submission?
Yes.
Kindly gives me a week's time. Let me speak to the client because they have not filed a special leave petition from the order passed by Justice Devanshu Bosak's division bench. That is true. I was, Miller, trying to impress upon your lordship that the order passed by the division bench earlier was only restricted to interest, but as fallen from your lordship, Miller, we have not just paid, but we have paid even after the division bench had pronounced the judgment. So, Miller, kindly allow me to speak to them. Gives me a fortnight's time.
Heard the learned advocate for the appellant, full stop. After some argument.
The original side appeal, my lord, that is also tagged with this, my lord.
Yes, please give us a list of the various litigation. We will take cognizance of this. We are being very clear so that they know what is going on in our mind. There are judgments of the apex court and instrumentality of state or such organization indulging in such litigation.
I'll impress upon them.
What is this? And to contest such a claim,
It's a
gratuity claim.
difficult brief to
Every petitioner you will come up in appeal.
There are also a few more petitions which have
saying that there was no profitability or there was no affordability and litigation after litigation you are contesting. Wonderful.
But Milord, the affordability calculation, I couldn't Milord, myself get convinced because it was a tremendous figure of 140.
You need not be convinced. You are bound by an order.
Yes, that is there.
Your convincing will not be required. That is what we are saying.
I'll definitely Milord speak.
That's our prima facie view. You take instructions. If you still want to contest, we are not stopping you. Yes.
I'll come back before your lordship. I'm deeply obliged for this opportunity.
Yes.
Grateful.
Item number 62.
Basically is appearing on behalf of the respondent. And, he's here, but he's included.
Ask her to come. What? No, the learned senior advocate has made his submissions.
Yes, sir.
We have recorded. It was fixed for your submission.
Instruction. Yes, sir. It's not possible. Fine. No. Not possible, Lordship.
Please. What to do?
Lordship, she's coming.
May it please your lordship. Lordship, it was the pay scale from the praise in the petition, lordship, apart from the date on which the scales are to be taken effect, there is no dispute because they've got the scales that they were petitioners were asking for, scale 16, like all other medical services. Non-practicing allowance, that prayer has also not been pursued. So now the question is from when the scales were to take effect.
Prior to 17.
Whether prior to 7, whether it should have been taken effect notionally from 1986 and from 1988, or what they have got is 1996, 1998. Lordship, that is the only issue that is to be cleared.
Benefit of one PRC.
Benefit of one PRC.
Benefit of one PRC, whether they will get or not.
Lordship. Now, Lordship, what I have, Lordship sees that comparing with the other medical services and look at doctors in India on the 23rd of August 1995.
This bench composition did not consider the matter on the last day. No, it's not part heard, but substantially we have heard the matter.
I checked whether part heard is not.
No, it's not part.
So that is why not, I felt.
And just now his lordship pointed out, so he is correct. What do you suggest?
Let him tell your lordship's discretion.
What we are doing uniformly is we don't know how this bench will continue. So such matters which we have substantially heard in the other composition, we are adjourning it for 2 weeks. If this bench continues, you make a short, you refresh things, we proceed. If we resume in that bench.
And a different bench comes.
So it like in any other composition, because substantial notes have been taken, you can just refresh and we can proceed. So after 2 weeks. 9th we are fixing, we have fixed many matters on 9th in that bench. So we can have it in that bench on 9th. As it is, if that date suits both of you, we can have it on 9th.
As your lordship please.
The at 2 p.m. fix it.
I get the new much.
Item number 63.
No, we are passing on. You reminded us yesterday, then we passed the order. We find no cases made out for interference. Taking into consideration pendency of the appeal, we modify the order of the learned single judge limited to the time specified therein for the writ petitioner's reinstatement to 4 weeks from date of communication of the present order. That we have modified.
Yes, my lord.
He will also be entitled to count the period from the date of termination till reinstatement notionally for other benefits. No payments.
Good. Good. This actually dita video order pass হয়ে গেছে order pass হয়ে গেছে
Your name is already appearing now. It will be uploaded later. We have yet to just correct.
The campaign form. Item number 18.
When the
Yes.
Item number 19. 19, my lord, I am praying, my lord, 2 weeks adjournment, my lord. Because, my lord, the learned ESG, my lord, he has been engaged in the yesterday and he has received the brief in yesterday evening. My lord, he requested me to pray before your lordship.
Mr. Francois Leonard.
I consider that judgment is still in one case. He relied on it to allow them. Second. So, considering an issue, balance of judgment, it will be more difficult for them to contest here. For the litigation, it will be difficult. They are considered more judgment. Second, but within 6.2 is same. 6.2 is akin to section 20. Something section in part. Same terms as section 20. Society.
So first of all, I can start, but as the opposite party is not here, Lordship, my efforts will be futile.
Where is the order passed in WP 24592?
592.
Your earlier rate petition?
Lordship, the impugn order is at page 148 regarding WP 13393 of 2019, Lordship.
Again, we are asking you, where is the order passed in WPA 24592?
452. Lordship, it is annexed at page 333 of volume 2 of FMA 472 of 2021, Lordship. Lordship, I'm for the respondent in this matter led by Mr. Gandhi.
বলিনি এখন ফার্স্টে তো আগেরটাই ধরবে 21টাই যেটা দুটো ফোর্স ভ্যালু
This order passed on your earlier MAT 706. That was assailed before the apex court also.
Lordship,
Where is that order?
unfortunately that word order was not annexed in the writ petition at that point of time. But it was dismissed, Lordship.
Dismissed.
Lordship.
So what is the claim in the present proceeding?
Lordship.
What is the claim in the present proceeding? Where is the order? It is again for the same promotional benefit.
Lordship. As at that point of time, the Honorable Single Bench and also Division Bench, Lordship, rejected my prayer on the grounds of delay only.
the merit was not considered, Lordship. Subsequently, after defeated in the Supreme Court, Lordship, I did not do anything, Lordship. But the government of India issued one advisory to the bank, Lordship. While I was in the service, and at that point of time, government was the owner of that bank, Lordship. Was the full.
This is not a development after the Supreme Court order. You are arguing as if all this has happened after the Supreme Court order.
Lordship, after the Supreme Court, the advisory was issued, Lordship, considering my grievance, Lordship, and the government of India directed the.
So after 2008,
Lordship,
you filed representation in 14, you filed representation in 17. All these matters considered, dismissed up to Supreme Court. Then again you filed a representation for which advisory was issued.
No, Lordship. The advisory was issued in respect of my representation earlier to the first writ, Lordship. I made representation since 2007, Lordship. At that one time, when I indicate that there is a malafide action taken by the bank for regarding implementation of interstate seniority, Lordship, my seniority was hampered. So from that point of time, I made representation, Lordship. And government of India, considering those representation, Lordship.
So now your whole claim is based on that advisory, Lordship. Now show us the advisory, Lordship.
It is at page 129 of.
Where is the advisory?
129 of volume 1.
It is in respect of which representation, prior to division bench or after the division bench?
Well, 2018. It is showing that is on consideration of email dated 15th December 2018, Lordship.
So therefore your submission that it is prior is wrong.
No, Lordship.
It's an incorrect submission.
But whatever they considered, Lordship,
is an incorrect submission.
Lordship.
Factually incorrect. Contrary to the record.
Lordship, whatever they consider.
Sir, when you make such a submission, you have no remorse. You are proceeding as if what is wrong if I have said something contrary to the record. We asked you that whether representation was after the division, you said no, much prior thereto. And the advisory refers to a representation of 2018, which is much after the division bench order. You think by making a false submission, you will get an order?
No, Lordship, I am not.
And then when we confront you, you just ignore it as if it is nothing big.
I mean,
at least you should tender at least an empty apology that by mistake I have done it.
Lordship.
We knew that it was substitute. We could assess from the facts that there is a relentless pursuit by this person. He will continue. Even after this court, again he will file such a representation. And then again he will come to the court. How this representation of 2018 can resurrect an issue settled by the division bench order? That is the only issue. Now tell us. Which law supports this?
That writ and the division bench order and the Honorable Apex Court, Lordship, consider only the delay, Lordship. As I made prefer the return.
And we should consider what?
Lordship, that entire crux of the matter is that.
And if we leave something, then you file another writ petition that this was not considered in that case. What kind of submission you are making, sir? An issue which was belated in 2017. Now it is revived because you made a representation after 2017.
My grievance was never considered, and
we are not on that. We are on whether it can resurrect a settled claim. Tell us, show us the law that making of a subsequent representation revives the cause of action. Show us. And that now we have to consider everything on merits, which was not done earlier. Please show any law.
When I prefer writ application challenging the non-implementation of this advisory, Lordship, this honorable court granted liberty to file a fresh, Lordship. I took that opportunity and filed.
So that will create a fresh cause of action.
Which indicates in the order, Lordship.
So that will create a fresh cause of action. Where is that order? Show us.
Page 137.
So for creating this cause of action, you filed and withdrew once. So that revives and that obliterates the decision of the division bench. Which page? 130?
131 starting. 137. Oh, sorry, 137, 138 is the order.
No, this is nothing new. Same thing reiterated for the fourth time. First in 2008, then in 2016, then in 2017, now in 2019. This is the fourth order to the same avail. That's all.
Lordship, then Lordship, can me allow
overcome the hurdle of delay and whether it is maintainable, or we will not hear you on merit. How this gives a fresh cause of action? Tell us.
Lordship, I'll try to satisfy your Lordship.
We are hearing you right now.
Allow
Enough is enough.
Allow me a day's accommodation.
No, sir. Not 1 minute now. (19/6, 2019), page 145. How it gives a fresh cause of action? There is a reference to the 2016 disposal.
Lordship, that order was handed over to the learned advocate.
How it gives a fresh cause of action? It refers to the earlier 2006 or 16 order, which is already decided by the division.
Lordship,
read the second line. Forget about when it is handed and what you have said. That is not relevant.
I bow down to your Lordship that this
This is mere repetition of the earlier orders.
Lordship,
so after the disposal, if you represent again, they will give the same order. Then you come for the third time. You keep doing it. You may keep doing it till such time that it is dismissed with some consequence. Then only you will stop. Yes, maintainability on 2 points satisfy us, then we'll proceed further. Maintainability, whether this is a state now within the meaning of Article 12 and delay, both issues. What judgments you are relying upon? Tell us.
On that context, Lordship, kindly allow me today's time, Lordship. Kindly fix it tomorrow, as because I have those.
Next appeal relates to that. The next appeal relates to that.
Next appeal
Yes. Two matters are there, 21 and 22.
by the same person.
By the same person, where it has been, the second appeal, the learned single bench has also been pleased to hold, just now what your lordship has said, that IDBI has lost its character as a state under Article 226, so writ is not maintainable.
So after this, he has filed another writ.
Yes.
No, Lordship, that is challenging the disciplinary proceedings initiated by the changing management, Lordship. Changing management initiated that disciplinary proceedings, Lordship.
But the bank is the party, and bank has lost its character to be state under Article 12 of the Constitution.
The disciplinary proceedings was initiated on the grounds that I made representations to government authority and that malign the character of the IDBI bank. Whatever fallen from your lordship's lordship, I have to place some precedents, lordship. Only for that, lordship, as today I couldn't bring those.
Heard the learned advocate for the
is concerned, the territorial jurisdiction is also under challenge. The first writ application, because everything was done from Hyderabad. And on that ground also the London single bench was kind enough to dismiss the writ application.
delay,
Thursday.
That's 27.
At 2 p.m. At 2 p.m. Can it be subject to your lordship? Can
We'll
you
see, let it be listed.
It will come, don't worry.
Let it be listed.
Lordship, I tender my apology, whatever wrongly done by
I'm telling you for my
Lordship. Lordship.
Item number 22.
22. No, 20.
So order passed.
20.
Next case also order is passed. In the next case also order was passed.
Lordship, is there Lordship, is the original affidavit and
For the petitioner, my lord. In this case, my lord, the crux of the matter is, my lord, that petitioner was entangled with a criminal case. He had retired from the service. Now the fact remains that this honorable court, my lord, in its jurisdiction, my lord, under section 482 of the Code of Criminal Procedure, had passed a certain direction, directing, my lord, the court of competent criminal jurisdiction to dispose of the matter within a certain period. Since there are, my lord, huge number of, my lord, the witnesses, my lord, the court possibly could not complete, my lord, the adjudication. I retired, my lord. Now there is a memo of the issued by the government, my lord. But in this case, my lord, I must state one thing, subject to what my learned senior friend will say, my lord, that my implication in a criminal case, my lord, did not, my lord, induce the department, my lord, to proceed against me by issuing a charge sheet. It means, my lord, there was no departmental proceeding. On this score, my lord, I made a representation to the authority that if the disciplinary proceeding is continuing as per 80 my lord memo, I have relied on a division bench judgment of your lordship's coordinate bench, that my lord, which says if the departmental, if there is no departmental proceeding, or if the proceeding is continuing, my lord, for more than 3 years, whether I am entitled to get, my lord, the benefits, my lord, attached to my post. Now, my lord, the problem here is, my lord, when my right was alive, I approached your lordship's court. It is not that after cessation of the relationship between the employer-employee, I came before, my lord, for assertion of my right. It is not a case. When my right was very much alive, I came to your lordship's court. Now today, my lord, the Supreme Court has, my lord, come up with a, my lord, a proposition of law which says, my lord, if I was sitting on the fence, my lord, I was sleeping with regard to my right, and my time, if I miss the bus, my lord, after retirement, I cannot, my lord, urge for, my lord, getting the promotional benefit. That is the law, my lord, of the day. Now, my lord, today, I say, my lord, because the government, my lord, never, my lord, took any initiative, my lord, to address the issue, my lord, with a proper perspective, my lord. That is, my lord, my case. My lord, I was entitled to get promotion. My junior has superseded me, and I did not because of the this criminal case. And my lord, I also made a submission that, my lord, if this is the law of the land, my lord, as of today, that my entanglement in a criminal case, my lord, everyone is presumed to be innocent unless I'm proved guilty. If that is the law, my lord, the presumption, then, my lord, whether the decision or the silence, my lord, it affects my right to be considered at least. I have no indefeasible right, my lord, to get a promotion, but my lord, my right. I was not subjected to disciplinary proceeding. I was not suspended.
You have not said anything whether charge sheet is filed in the criminal trial or not.
Yes, so a trial is going on. Trial was directed to be concluded.
You have still not said whether charge sheet is filed in the criminal trial.
Yes.
What is the date of charge sheet?
That is, my lord. Lord,
Lordship charge sheet.
2017, my lord, May 2017.
And you are claiming the promotion with effect from which date?
Just a minute, my lord, it is not network, is
Lordship is the original affidavit in opposition and the records, Lordship.
No, these two dates are only relevant.
I mean, because I find there is an affidavit was affirmed, but I don't.
Pinti, let us ascertain this fact.
The Lordship, it was filed on 20th of May 2017. And
No, we are asking what is the date from which, with effect from which he is eligible and is claiming promotion.
The representation developed. May I come back Monday, my lord, on Monday? My lord, it's not working, my lord, I have no paper, my lord.
With effect from 22. You are claiming MCAS benefits. Not a
I said, my lord, that benefit has also not been paid. Also, I said, after 16 years. I said, my lord, to the executive, I said, my lord.
Completion of 60 years of service from the year 2000.
I claim, my lord, 2001.
2001.
Paragraph 8.
Paragraph 8.
Yes. And in-cash benefit from 2022, it is a prayer, my lord. 70.
No, that is from 23. What other promotion you are claiming?
From promotion to the post of executive engineer.
From which date, sir?
Paragraph 8, I said, my lord, from 2001.
Paragraph 8.
Page 5, Lord.
Just a minute. May I come back on Monday, my lord? Because the paper I not what.
Paragraph 8 is regarding MCAS benefits.
Not talking that. English will be clear.
So most of 2001, 16 years.
Yes, my lord. That is a in-cash when your lordship is right.
Then can we consider prayer C?
My lord. Rita Mandamus servants MSc benefit 16 years, yes.
Yes, from
Yes,
the service
yes.
from the year 2022.
Yes.
No, May 17, whether it is a claim prior to submission of the charge sheet or subsequent, that is the only thing that we have to see.
Subsequent. Charge sheet 2017.
So subsequent to charge sheet, you can get a promotion.
Criminal case, my lord.
Criminal case, yes,
criminal case. 9 years have passed. There, I do not have any control. High Court said, my lord, in a court, the jurisdiction, my lord, under section 482, that you have to dispose it of. Suppose, my lord, there are 26 witnesses. Justice Ghosh has passed this order. The court could not complete it, my lord. There is utter failure on the part of the prosecution.
So therefore, what happens in such a circumstance? What does the law contemplate? That we are asking.
I relied.
Date of
State
filing
was directed to bring the circulars, my lord. I was relying on only one circular. Justice Mr. Tapan Mukherjee learned additional government at that point of time. He was directed to place, my lord, the
you relied on some circular or notification which said that provisionally some benefit should be granted if there is an inordinate delay.
Yes, Milord, I relied on a judgment of a division bench and a circular of 1980. But Milord, Mr. Mukherjee was of the opinion at that point of time, there is a subsequent circular which discards my claim.
So therefore, if 1980 is not tenable.
Yes, that is why your lordships wanted him to produce that. Now I wanted a division bench judgment, Milord. 1980 has not been repealed, that was my submission.
Opposition.
জানিস না কেন ওখানে দাঁড়িয়ে থাকে কিছু কিছুই জানি না
So this division bench says ad hoc promotion. That's what we are saying. You cannot get a promotion.
Ad hoc promotion, Milord, that is why your lordship said today, Milord, subject to, Milord, the outcome of the criminal case. That was the concept. Yes, but the question is, Milord,
the date of submission of charge memo in the departmental inquiry and charge sheet in the criminal trial. The promotion cannot be granted.
Kindly sees, Milord, the department in its wisdom thought it fit and proper that the pendency of the criminal case, it did not inspire, Milord, the confidence of the, Milord, department, my employer.
That's not relevant.
Milord, maybe, but Milord, disciplinary proceeding is far more, Milord, on a stringent side because of
No.
The preponderance of
Janki Raman says both submission of charge memo or submission of charge sheet in the criminal trial. Once it is done, the proceeding is in. There is a bar to grant of promotion. The promotion be considered, kept in sealed cover, and only after that. You said that no, there is also a circular and notification which says that under such circumstance, ad hoc promotion be given.
That is the judgment of Justice Division Bench.
WPSC 154.
That is what on. To that, Mr. Mukherjee said that there is a further circular. That subsequently there was a circular.
That is only issue now. Whether that circular is in vogue or not in vogue.
The question here is subject to correction. I sought to impress upon your lordship that my right to be considered, whether, Milord, it can be, Milord, in a state of limbo.
No, it cannot be.
No, because, Milord, today, Milord,
it's not in a state of limbo.
No. Question is that what is the significance?
The consideration is not kept in limbo. Benefit of the consideration is kept in limbo.
Yes, that means, Milord, I cannot.
Consideration already took place and sealed cover procedure must have been adopted.
Milord, that is why you kindly ask.
Therefore, whether ad hoc you can get or not, that is the only issue. There is nothing else.
Milord, I, in the service rule, subject to what my learned senior friend in West Bengal, as per the service rule, my employer-employer relationship is governed by a rule. Whether, Milord, this rule, Milord, speaks about any seal cover procedure, Milord, or government maintains it.
The law of the land,
The law of the land, Milord, in the context of the rule.
Yes.
Subject to correction. Kindly ask my learned senior friend.
Please see the judgment. Please see the judgment. KV
Janki Raman. Milord, in our service rule, Milord, the ad hoc promotion which speaks about ad hoc promotion
of KV Janki Raman very well elaborates on this aspect. It goes on to say why such a procedure is adopted. It says that under a circumstance where a charge memo is served or a charge sheet in a criminal trial, it may not be in the fitness of things to grant a promotion.
Correct.
It goes on to say so. So whether your service rule provides or not, the law is very clear. But it says it has to be considered and kept in a sealed cover. And benefits to be granted.
In this case, Milord, my learned
Therefore, the only issue is whether that ad hoc can be granted to you or not. If it can be, then you may get. If not, then you cannot
yes,
get.
Milord, that is why I will show, Milord, the Janki Raman, and I will also show the service rule also. I will show the service rule, Milord. Janki Raman.
No, we accept what you are saying without going into it, that there is no provision for sealed cover. Still, if there is no provision, then after a charge sheet, you will be granted a promotion.
That is why, Milord, where is the impediment I put this?
In KV Janki Raman,
I will show. I read for your lordship on the last occasion, paragraph 10.
Yeah.
Your lordship wanted me to read because your lordship memorizes the entire judgment.
No,
I do not. That is, no, Milord, it is not a question of flattery to the bench, Milord. What happened, the reality, Milord, is this, that I wanted to read the entire judgment. It is your lordship, Milord, asked me to read paragraph 10. And on that day, Milord, Mr. Mukherjee, Milord, said that's 80. But if I say, Milord, whether I'm correct in making this submission, that my right must be adjudicated in the context of a service rule. Whether Janaki Raman is a law laid down by the Supreme Court. But question is, Milord, that the law has to be read, understood, and meant in the context of, my lord, my relationship. Question here is, Milord, why I tell your lordship? Because I can show your lordship, because on that day, Milord, I have a judgment to show your lordship that if the government makes a solitary rule, it is a rule under Article 309. Suppose rule is silent. Now, Milord, what is the ramification of this, Milord, silence? If the rule does not say anything, this particular rule, Milord, may I, Milord, try to see page 171, paragraph 12, Milord, which says silent, then the government is precluded, Milord, take any external aid, Milord, to interpret the rule. Because the rule government find in source or cannot take any action, reports to any action, do not permit it to do so. That is my understanding, because Janaki Raman was I bow down to my lord that the law laid down by the Supreme Court the entire country. But at the same time, my lord, the Supreme Court also, my lord, says that this Janaki Raman, in that case, my lord, I still do not have the, my lord, the exact paragraph, my lord, this cannot memorize, my lord. The 10, my lord, when it was read, my lord, I possibly, my lord, got some honorable passage to confront, not, but to, my lord.
Now we remember you had placed that circular or memorandum saying that ad hoc can be granted.
Yes.
Then only we said that at best you can get that.
No, minutes, huh? That is what my prayer is. Subject to the result of the criminal trial.
That is with, even if we don't grant you, it is subject to result.
But they will not. Unless your lordship says something, they will not. Because they have to rise to the occasion, and such inspiration must from the bench. Government is run by the infinite minor. এটা ইয়ার হচ্ছে নাকি?
Yes.
ইউটিউব হয়? দেখো একটু কথা বলে। কথা বলে। দেখুন না কেন মামলাটা? সরি বলে। 23rd March, 8 March 1973. Government subject having doubtful integrity, instruction, it is torn, my lord. It is ছিঁড়ে গেছে।
23rd March 1973.
না 80 সালে আছে 80
80 what?
No, that is not. That is Mr. Mukherjee. This is Miller. 28 March. It is fresh copy. 80 is there. But 12 June 1980. 12 June 1980.
June 1980 is in the opposition. That is in the opposition.
And 28 March 1973. 12 June 1980 and 28 March. It is
the next to the affidavit in opposition. Whether
73.
73.
That is Mr. Page 131.
81.
80. 12 June 1980.
81. The one issued in 1980.
81. No, it's 1980.
Not the one issued in 1980.
Oh, Lordship one issued. Lordship is the
small Roman 3.
Should be held at a small Roman 3. Has been placed under suspension or government has started criminal proceedings against such government servants in a court of law.
তোমার কাছে বেটার কপি আছে?
না কোনটা এটা তো affidavit in opposition আছে না it's the affidavit in
এটাই না
that because I have I mean it's in the record, it's been filed. Okay, and then it's been filed.
The confirmation promotion Roman 3.
Roman 3. E2. Additive. Happy. Elder. Elder in a case.
Sir, the question of confirmation of promotion government servants when conduct is under investigation or against whom disciplinary criminal have been started. Contemporary has been under review of the government. After a careful reason, said that the confirmation, promotion, efficiency for selection grade appointment of a governmental servant, recruitment in service candidate higher post should not be held up merely because the confirmation, promotion, efficiency for selection grade appointment of government servant, recruitment in service to higher post should not be held up in cases where disciplinary proceedings having been started have continued for more than 3 years, unless the delay in disposal of the recipient is due to any dilatory tactics employed by the government servants concerned or due proceedings in a court of law started at the instance of the officer concerned. However, when confirmation, promotion, efficiency by crossing selection grade, appointments or recruitment of in-service candidates to higher post is allowed to anyone against whom disciplinary proceedings are pending, it should be ordered to be on provisional basis. The confirmation, promotion, efficiency by grade appointment or recruitment service to higher post should be held up where government service has been placed under suspension pending disciplinary proceeding or government has started criminal case proceedings against such government in a court of law. The instructions contained in Home Department such and such 73 copy refers to selection of officer for appointment to administrative extension remains in force. However, para 1, 2 of that memo which refers to selection of non-gazetted post to gazetted post for the first time should be treated as cancelled. Accordingly, the works to gazetted post from non-gazetted as occurring in para 2 of the memo should also be deemed to have been deleted. This order does not anyway modify the memo dated 25th. Yes. Now, Milord, the Milord, whether the two the proceedings to the year criminal. And Milord, this division bench 154 your lordship has read, Milord. Your lordships have read, Milord, to 154.
এটা 80টাই বোধহয় হ্যাঁ
এটা নাও
73 এটাই
So, okay, book the line addition of that function of the trial of the said criminal case according to the parties, we find that the authorities concerned do not constitution trial in question and ad hoc promotion was according to the private sub-inspectors who are also considered granted ad hoc promotion pursuant to the minutes of the conference for considering such and such promotion to the sub-inspectors were granted special ad hoc promotion. So, the special promotion is not on the government.
There it appears that certain other officers were granted that benefit and therefore the court said you should be granted.
Yes. Now, Milord, in this case, $125, Milord. 125. such and such and substation subdivision such and such. I joined the department Southeastern Region, and thereafter I was promoted to the post of SME such and such. I must have some service, sincerity. Complaint the corruption don't. On
Yes, you have paid for this benefit. Come to the page 126, second paragraph.
So service in terms of the observation such and such. Sincerely.
Yes, for want of integrity certificate, they are not.
Yes.
Cannot.
Nominal this
Integrity certificate is mandatory under your service rule.
Is control in so now I tell you, Lordship, Millard, that was my submission, Millard. Only Millard, this court, the only because the criminal case is pending.
Only question of integrity is pending.
Only question of integrity. Now, Millard, it's a charge sheet, Millard, and trial is going on.
So therefore, let's see the judgment.
Yes, Millard, I would have Thursday possible? Subject to correction.
Very well. Thursday. After some in the opposition, they have taken a stand that is in the sealed cover. They have said so. As per rule, I don't know which rule they are relying.
No, I will first rely on the Janaki Raman, then I will show a judgment.
I think we should first see Janaki Raman, then whatever judgment you want.
Instruction নেওয়ার কিছু নেই দাদাই না ক্রিয়েট আজকে নাম
Item number 23.
In this matter, I'm on behalf of the petitioner, Malat, and led by Mr. Lahir Malat, just little before he left the court, Malat.
What do you want, sir?
I'm praying for not this week, Malat, only.
I have sprayed list after week. You are appearing and AGP is present. I have sprayed list after 1 week.
1 week.
27.
Item number 24.
24, my lord, I am for the minor child respondent.
Responded. Petitioner was here.
He was here.
Yes.
I am appealing for this one for 4 and 5. Not today, call the next. You must have gone to attend some other days. Not today?
Not today.
Item number 25.
For the appellant.
I am for the respondent one.
My lord, I believe, my lord, the appeal can be looked into from two different angles. One on merit, another your lordships, one or your other. The respondent writ petitioner has got appointment, but not in the transgender category, which the learned single judge directed, but under the OBC category, he has got it. Now, the point in the appeal, your lordships, in view of the Supreme Court judgment, or the Honorable Supreme Court directed both center and state to come up with welfare schemes. As your lordship knows, the court should not direct the state to frame the legislation. So this was, my lord, the direction of the Honorable Supreme Court that was pending, still pending. My lord, so far our state is concerned, law has not yet been framed. But the learned single judge was of the view, in view of the observation or direction of the Supreme Court, that it should be done immediately, and so long not done, the West Bengal Board of Primary Education should keep 1% vacant for transgender and give them a point. But being a statutory authority, I can't go like this. So this is the merit, your lordships. But otherwise, he has got the appointment. That's why I put the appointment letters, your lordships. So, দিয়ে দিচ্ছি তোমাকে, এটাই দিয়ে দেবো আমাদের ক্ষেত্রে। The appointment letter and the next page, my lord. Board recommended recommending.
But according to you, the appeal survives.
Least, my lord, according to me, not, because we cannot proceed, my lord. How could we make reservation unless the state passes appropriate legislation?
So therefore, according to you, the appeal still survives.
That your lordships can dispose of in view the petitioner has got the appointment, dispose it of. Direction was to appointment of the petitioner. May I take your lordships to the direction portion?
Please, yes.
Kindly, your lordships.
No, you said it is in 2 parts, that's why.
That's your lordship. It starts from page. Paper book number. No paper book number. FMA 942. Well, state has also preferred an appeal. No.
Yes, FMA
942. Your lordships, the judgment starts from page 85. 185, I'm sorry, Malad. 185, 14th June 2024, the judgment dated. Malad, I take your lordship first to the Direction of the Honorable Supreme Court or the observation at paragraph 5, page 186. This has been quoted.
One
188. 186. Internal page 2 of the judgment starts at 185. Now, your lordship, relevant portion, your lordship, 135.7, 135.8, 135.9, 136 at page 187. Then you say paragraph 8 at page 188. Direction has been given to the Chief Secretary to ensure 1% reservation. Malad, that's why the state filed an appeal. And so far we are concerned, Malad, paragraph 9. Malad, in paragraph 9, Malad, this was not
the writ petitioner.
I for the primary school, West Bengal Board of Primary Education. Malad, paragraph 9, we are agreed. Without the reservation, I cannot select someone in the category, my lord. Even if your lordship, the direction is right 8, if your lordship held that. Even then, so long that is not done, I can't. This is one thing, your lordship, kindly see the other thing. At that, kindly see page 190. What করতেন? Go slowly. অতক্ষণ তোকে তুই একটু বস না।
I think Mr. Sandal.
No, my lord, it's only 5 minutes, I think. মামলা করতে page 190, your losses kindly consider.
One thing, my lord. So far the petition is concerned, we came to know that he has been appointed. But so far there are certain other directions, my lord. Kindly see some of the orders, my lord. They were directed. There was a committee formed by the state. That committee was directed to place the report before this court regarding the implementation of the Supreme Court order passed in the Nalsa judgment. That report was probably, that report is required, my lord. So far the petitioner's claim is concerned, my lord.
You are for the petitioner.
I was for the petitioners in the writ court, my lord. And here, my lord. So state's presence is very much.
So there are two appeals. So far my appeal is concerned, my lord, that should be disposed of. So long the state doesn't come up with a legislation, there cannot be any direction. And in the fact, more particularly here, he has been subsequently appointed. So why should I be, malad, unnecessarily to be entangled with this?
Well, this appeal has two parts, my lord. One is the judgment in rem, that part, because it is going to affect a lot of things, my lord. The constitutional position, Supreme Court judgments, and everything. The state's appeal is very much important.
And that's your lordship, my learned friend. Malad, kindly have a look your lordships, my lord.
No, but he is right. The boards, what remains for the board? If at all something remains, it remains for the state one.
Exactly.
Because paragraph 8 is not for him.
Well,
9, paragraph 9.
So for
8 for the state.
That's what we are saying. 8 is not for you.
Not for.
So far,
if 8 is
personally is concerned, my lord, I do not have anything.
So one appeal, if it is pending, the substantially.
Your lordship records their statement that I am appointed.
No, he has given the order.
If your lordship recorded, kindly their appeal, state appeal, my lord, kindly hear us before, because
Yes. We have understood. See, there are two things. One is that treating them as socially educationally backward classes in terms of the Nalsa judgment. That aspect has been, there is a direction in para 8 that 1% should be reserved. So that is for the state to contest. You are for the state.
Yes.
Insofar as the direction for appointment, there is no dispute that appointment is given, so therefore that appeal need not be kept pending.
So my appeal, my FMA 4942.
Chief Secretary of Chief Saraswati Bholish. That has to go Chief Secretary of
Yes. By recording session.
So let's see what it says here. This is the most important.
These transgenders have to be treated as socially and educationally backward.
So the other appeal, we will hear it whenever you want. Your appeal is appeal number
942.
The Leonard.
That's it. Well, here the question is that, well, what is the progress of the implementation of that judgment in this?
That's different.
We are telling you, this is a question of additional 1%.
And I believe the matter is still pending before the Honorable Supreme Court. I don't know whether it's at contempt stage.
Yes, my lord.
Much. Well, this is at least for me, my first appearance before Justice Roy.
The other aspect is concerned, they must be answering this issue before the hearing. So all the state governments must be a part in the NALSA proceeding.
Let's find out, my lord, what is the progress. I will ascertain.
Parallelly, the High Court in the division bench can consider this aspect if that matter is ongoing.
But I will consider.
These are things.
I understood.
Yeah, 17 September.
Grateful, man.
1195. Okay. It doesn't exist at all. Yes.
27.
Yeah.
Lordship, Lordship, I'm praying for a short Passover, Your Lordship. Learned counsel.
Whether opposition is filed already?
Yes, Your Lordship.
Filed. You have,
Not the
have you filed a reply?
We will be filing the reply, Lordship. Learned counsel Siddhartha Banerjee is appearing in this matter, Lordship. He's currently in some other court, Lordship. Kindly passes it over.
I know. You see, it has been filed. You. It properly. Tag it properly. In seriatim. Tag it.
Another contact date actually.
That was the file. You must have served. You have been given a copy of the opposition.
Yes, Your
You have
Lordship.
got a copy.
Yes, Your Lordship. Lordship, we'll also be filing our affidavit in reply, and we have served the state as per Your Lordship's last direction.
Who is appearing for the state? Earlier, Mr. Amal Sen was appearing.
It has last been served on June.
The writ petitioner's advocate is submitting that you have they have been served a copy of opposition, but no opposition is filed in the court.
I have to inquire.
This is your
This was affidavit of service.
This is the opposition.
Lordship, this was affirmed in the 21st of November, 2025. So it's probably with the advocate who was.
So you reaffirm it, get it reaffirmed.
Then একটু আমাকে কাগজগুলো দিয়ে দেবে. Then I.
You are recording your appearance.
Lordship, I'll do that.
MS
Lordship, may I file my affidavit of service?
No. Unless the opposition is filed, we have said they will reaffirm and file the opposition within 2 weeks. Then your reply within a week will take it. Because that opposition is not filed.
May this direction be peremptory, Your Lordship. May this direction be peremptory.
Let's see.
At my insistence, will submit.
No, we understand. As it is, we don't know who is to appear. We have asked him asylum to appear, and so they.
It's a stigmatic, punitive order of transfer. I am not allowed, years are passing. That's the only difficulty I'm saying. I just, not to prejudice your lordship, just to, by my lords, 1 minute's time. I was, subjected to sexual harassment. There was, internal committee formed. People were found guilty. And, without punishing them, now at their instance, I have been transferred. I have been punished after internal complaints committee held them guilty. This is what has
After
happened.
the ICC?
Held, my other side guilty. The accused persons guilty. There are recommendations for taking proper steps against them. That has not happened, and I have been transferred on their complaint.
But we don't have their opposition also on record. How we can proceed? They have served a copy on
If
it.
they choose not to file this.
No, the learned.
Now the learned senior friend has come, I have no difficulty. Till such time my learned senior friend was not there. There was no inclination.
No, after Mr. Sen's appearance since May, there is nobody.
Come up with this.
Earlier, Mr. Sen was appearing. After May, how he can appear?
That's why we are most
No,
probably
this
praying.
is-
If
Let them,
parented in this time,
They will reaffirm within 2 weeks.
Everything.
all grateful.
Yeah, maybe change of regime, change of status.
That is.
Change of?
After the change of regime, maybe the change of stand.
That will be to our fortune, Milord, if that happens.
That happens. One of my happens.
Call the next.
Item number 28.
Lordship, in this matter, there is a special bench judgment on this issue of the pay scales, Lordship, where our respondent was an honors graduate, but he had joined service as a past graduate. And thereafter, he claimed the honors scale. Lordship, it's a very long.
Had taken it up.
Yes, Lordship, I had Lordship, that they couldn't be completed. Lordship, I've come across a judgment which is 187 pages. I'll get it copied and Lordship will fix it sometime next week. I'll give it to Lordship. There's a judgment of the special bench on this.
There is a delay application also.
Delay of 216 days, but your Lordships had taken up the main issue. But I've served the respondent. He didn't appear on the previous day also. But your Lordships are hearing the main matter. There's a delay of.
No, have we recorded valid service by any order?
Lordship, on the previous date, Lordship, on the previous day, I filed the affidavit of service, Lordship. Affidavit of service is filed, Lordship.
No, you are supposed to file affidavit of service.
No, I filed it on that date. I think.
Oh, on 3rd August, we have recorded or not?
Yes, thereafter, Lordship, when the matter was
After
taken
3rd
up.
August?
After 3rd August.
No, it has not come up. Today it is being.
It's been filed. Just check it. I filed it on.
Last order is of 3rd August.
Last order. Day before yesterday. Lordship, day before yesterday, the matter was taken up. It should be with your Lordship's record. If your Lordship had checked the affidavit of service, being satisfied that I had served all the applications, it was probably on Monday or Tuesday, if I'm not. Huh? Oh, Tuesday, Lordship, probably Tuesday. Eight. Then. Monday was washout. No. Monday was a washout. Chatru na 18. Probably on the 18th. 18 ki?
ये तो ऐसे कि जोशुआ से original
18 taki?
After third, there is no order.
After third, there's no order. But Lordship, I had appeared.
Anyway,
Lordship had found the affidavit in.
yes, we have got only one copy.
There should be both.
yes
What's the order?
Then there are.